Item 23. 23. 23. Really low length. Okay. Petitioner is defective. Okay. Okay. Mr. Jibam, land counsel for the petitioner wants to withdraw this criminal petition with liberty to file afresh, if so, advise. Who is, you have any objection?
No.
Anyone appearing in this case?
No, my lord. I am
No.
appearing 20.
Are you in this case?
No, my lord.
Okay. 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 The petition is dismissed on being withdrawn with liberty is prayed for. Okay.
May I, Your Lordship? I beg to mention item number 9, Your Lordship. Item number 9.
9.
Yes, Your Lordship. We want to withdraw entire case, Your Lordship, because it has become infructuous.
Okay. Mr.
B. Dulom.
Land counsel for the petitioner wants to withdraw this petition is it has become infructuous.
Yes, Lordship.
Stop. This petition is
Your Lordship, we may be given liberty to file a fresh one again.
on being withdrawn with liberty is prayed for. Liberty
Yes, Lordship.
with liberty to file a fresh if so advice. Okay.
No, obliged. May I?
Your Lordship, I like to mention item number 18.
18.
Yes, the complainant passed away, so we need some time to.
Who passed away?
The complainant.
Complainant.
Yes.
Okay.
We need some time to replace the legal representative. So this
Okay.
item may be.
Mr.
Anyway,
Land counsel for the petitioner submits that the informant in the instant case expired and prays for some time to file a substitution petition. Substitution petition of the prayer is allowed. List this matter after 4 weeks. Okay.
give your best.
Your Lordship, I beg to maintain item number 19 and 20 on behalf of Mr. D. Pangyang. I have taken consent from the other parties. Matter may be listed after 3 weeks.
Okay. You are Mr. You are Mr.
C. Tajo?
Land counsel for. Your name is there?
No.
Okay. Appearing on behalf of Mr.
D. Pangyang.
Deepang, land counsel for the appellant. On the consent of the other side, praise for listing this matter after
3 weeks.
3 weeks. The prayer is allowed. List this matter after 3 weeks. Okay.
Much obliged.
Please, Lordship.
Yes.
Lordship, I beg to mention item number 21 on behalf of D. Pangyang.
Okay.
I have taken consent from the other party. Lordship, the conducting counsel from the other party is from Guwahati, P. Sharma.
Okay.
So,
My lord, I am appearing through PC, my lord. I am for the
For-
appellate, my lord.
For the
Including
appellant,
Yes, my lord.
fix that
They
may
are
be given,
seeking-
Lordship.
seeking adjournment.
My lord, they are seeking adjournment basically. Oh, I have given my consent, my lord.
Okay. You have given.
Yes.
Okay.
Fix that
So
may
when
be
do you
given
want?
on 16th of May.
16th.
Yeah.
Is it okay?
My lord, okay.
Okay. Miss,
Rosie C. Lawangcha.
or just you are Mr. Mehdi,
No, my
Mr.
lord, BM Deka. My name is not showing there. BM Deka.
BM Deka. Mr. BM Deka, land counsel for the appellant. And Miss
R.C. Lawangcha.
Longji, land counsel for the respondent. Stuff is prayed for by the land counsel for the party. List this matter on 16/5/2024. Okay.
Obliged.
Much obliged, my lord.
My lord,
Yes,
I beg to mention item number 16 and 17. On behalf of Ojing Pada, he is out of station,
okay.
so matter may
So
be
who is
listed.
for the appellant?
We are from the respondent.
That is why. Who is for the appellant? You have taken consent from the appellant? No.
Yes,
Okay. Miss,
C. Tabang.
appearing on behalf of Ojing Pada, Land Council for the respondent, on the consent of the Land Council for the appellant, praise for, when do you want?
After 4 weeks.
Okay, listing this matter after 4 weeks. The prayer is allowed. List this matter after 4 weeks. Okay,
Most obliged.
in both the case. Huh? Mm. Yes. Yes. Who is for the petitioner?
Petitioner party is not there.
Hmm?
It's absent today.
Okay, no one appears.
No, sir.
Yes, what is this?
My lord, this case we was already quashed and I have given the order copy also to the honorable court in this one, Geography first class. Then after quashing of the case, still by the direction of the honorable Guwahati High Court at the hearing of that, only one accused person we have we have joint petition filed before this honorable court during at the time. But during the time, honorable PP, she have stressed that all the accused persons should present. Then during that time, only Sunil Lokhatia, the co-accused whom his honorable court has lost during that time, only he and the complainant, she both has filed it joint petition. So with that, she has directed that, okay, then I will quash regarding only Sunil Lokhatia and rest she will not quash of the FIR copy. But during the this one hearing time, the FIR, it was directly quashed with the reference like in page number. So last time, Honorable Cardiac Officer, he was the hearing during that time. He took the hearing and he said like once the FIR is quashed means that is directly quashed. So confusion is regarding
Where is
after
where is that order?
that order. That para 9. Your
No, where is that order? Have you annexed that order?
Yes, I have an annex.
That's
91, annexure P7. This is the quashing of the order of this Honorable High Court. It
so
was
this
passed-
by this order.
yeah. The FIR itself has been quashed.
Okay, then what do you want now?
Now, again, the bail-level arrest warrant came for one Rites Lokhatia, who is also a co-accused in the same case. So confusion is there. Once the case is quashed, then while other co-accused is again
You
warranted.
inform the court there.
Yes, I have even annexed and given this order copy.
Okay.
But still regarding that, next day again the hearing came and with that, Rites I have already filed recall and arrest warrant, and plus I have annexed the order copy. But next day, again to the bailer and other co-accused, again arrest warrant was sent. After getting this quashing order also, which I have annexed. So that is the confusion part. So I again came before this honorable court intimating that with the case, again joint petition I had filed. Okay, then it was for Sunil Lokhatia. If at all it was quashed, then again same order may be passed for Rites Lokhatia, who is the present accused person
Just a
here.
minute. They are proceeding of GR case number. Is this the GR case number? GR case number 78 was first. 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 So. Case number 21.
In page number 90, my lord can peruse it on 28/2/2004. That is
Page-
this
page?
year. Yes, page number 90.
90?
Yes, 90. Page number 90.
No, no, no. The case which was quashed
Oh, quashing order. Quashing
in
order
the criminal
is-
petition 138. What is the number of case number?
Page number.
Case
91.
number. Case number.
Oh, case number.
Case number which was quashed.
Oh, case number GR number 78.
78.
2009.
Okay. Now let us see the. And if you have come here praying for quashing of
Recase
Nahalagan PS case number 21. Is it the same one?
Yes, 21 same one. That is 78. GR number is 78/2009. And he is one of the co-accused in this same case.
Just a minute.
In
Just a
final
minute. Just a
report-
minute. Just a minute. Let us confirm the name and the case number. Is it-
Here.
This is case 78.
Recase Bakutia in page number 33.
Just a minute. Let us
final
confirm the
report.
case number first.
Oh.
This is 78.
17 is GR number.
Hmm?
GR number.
78 GR number.
Yes.
The case is pending before which court?
Your Honor,
Case was pending before which court?
Genetic court.
JMFC. Okay, this was quashed on which date? 26/9/2023.
Yes, 22.
Okay, so this order was presented
Yes, present, page number 90, Your Honor, can say.
90.
Yes, 90.
What is
This
this?
is the 28/2004. This is the latest order.
Just a
That is order
minute,
passed by the
This
Honorable-
was
Honorable Genetic court
23,
after getting the order,
24.
quashing order from here.
Nahalan PS case number 78.
GR number 78/9, same. This is the same case. And notice has been given to the bailer also here, again, fresh summon with the accused absentees along with the notice to the bailer. The next date is fixing for July. That's why I had come and prayed before this honorable court for quashing the just an FIR number 21/2009 against Regis Lokatia with the complainant. And this
No, well,
already
no,
is
no,
quashed off.
no, just let us see where, by which forwarding letter you have submitted this order, quashing order before the JMFC. Have you submitted this order before the JMFC?
Yes, I have.
Yes, where?
My lord.
Where do we find the records?
In 27.
Where?
No, that one I did not vote, but my lord, during this time.
No, you have to show where you have presented this order or this order reached to the JMFC and
Because-
JMFC have received, and even after receipt of this order, JMFC has issued another order.
I note in my, this one, not that much clear. In PP copy last time, I have shown to the honorable.
No,
Judge
you
also.
just satisfy the court, this
Yes.
court,
Sunil,
that you have presented-
in charge sheet, it is quashed, already proceed, put up and quashed. It is clearly written, my lord can please bear with in the CC copy,
charge sheet.
charge sheet copy, it is quashed.
How
It's
how it can come in the charge sheet?
No, it,
Charge sheet was already filed, it appears
yes.
before the court, and then the
After
case
submit-
pending before the court has been quashed by this order. How the charge sheet come now?
No, your honor, when I have submitted, this was in 27 February. Of this February 2004. After that one, they have reflected in Sunil Lokatia proceeding that one put up
No,
and
no,
it was
my
quashed.
counsel, please try and understand whether you have presented this order before the
Yes,
JMFC.
yes, that's why they.
Where
have-
do we find the records that the JMFC has received this order? It is in the
Latest-
case record of the
latest,
JMFC.
CTC copy I have to come from
So
the.
wait,
Yes,
has it
yes.
reflected?
Yes, it's reflect their.
Page,
Sunil,
page.
uh, 27, annexure P3.
Page 27.
Yes, annexure P3.
Annexure P3.
Yes, my lord.
This is
here
final
in-
form. This is charge sheet.
No, here in serial number 11, it is, you can see here, Sunil Kumar Lokatia, proceed, put up and quashed.
Hmm?
It's written with the hand. Serial number 11. 11, name Sunil Kumar Lokatia, proceed up and quashed.
What is this?
This is last order in.
No.
Honorable court has quashed up against.
No,
Sunil
please try to
Lokatia.
understand. This quashing order was passed on 26/9/2023.
Yes, and after that one in 27th of this February, I have submitted this order of.
Where do we find that?
That's why last time honorable court has.
You must have
that-
forwarded,
that
you
the
must have
PP
forwarded, you must have forwarded this order copy or submitted.
Order copy I have submitted to the quashing order.
Where do we find that you have submitted and they have received? The court has received. Where do we find that?
That one, that direction was given to the PP to inquiry about it.
It was presented before the JMFC.
No, Lordship, last time, Tado sir appeared in.
Whether this order was presented before the JMFC. This,
Last order,
no, the quashing order.
quashing order, no, I was not directed to place quashing order before JMFC.
Did,
She has to place.
you have to show us. Because there's no direction to the PP to obtain copy and to present it. So you have to satisfy and you have to submit a copy of this quashing order. See, before the JMFC saying that this is the order, the present case has already been quashed. So kindly close the case as per the direction of the court. You have to submit before the JMFC and get an order passed that proceeding closed. Case quashed by the High Court, case closed. Where is that order? Where is the letter that, which shows that you have submitted this copy before the JMFC? Unless it reached to the JMFC, JMFC would not know that the case has been quashed or not. It will continue. The proceeding will continue unless you submit it. Why you're taking pain to submit this?
I have submitted, sir. They
You
have
should
not
have confirmed. You should have informed there in that court.
I have informed, and it has been reflected out in your proceed and.
No, where it is reflected?
In P.
Try to understand. This is charge sheet. Charge sheet was submitted before the court, and long after charge sheet is submitted, the case will register, and thereafter it will proceed.
This is the latest one CTC copy that I have to count. Before, in all cities, charge sheet, it is not reflected. Washing was not reflected.
This is not an order. Who has written this? How would we know that this is written by the court and this has reached to the court? And you have brought this to the notice of the court. You have to bring it to the notice of the court. That case has already been quashed. This court has no right to proceed with the case. Approach the trial court first and present this copy of this quashing order and praise that since the proceeding of the case has already been quashed, this court cannot proceed further. Make a prayer. Accordingly, they will close. The JMFC will close. But unless you produce it, how do you expect that the JMFC would know? What do you want?
Then my lord may allow me to give the submission before the JMFC.
See, unnecessary you have challenged. We have not yet presented.
So I have even submitted this order copy. I have already submitted,
You are not
but
prepared.
they have not reflected in the order.
Come prepared. Your point, all points, that whether you have complied or you have followed the procedure, then only you should come. Go to the last resort. Let's pray for by the land council for the petitioner. List this matter after 4 weeks. In the meantime, you with the proper forwarding address to the court, the case has been pressed by order such and such order. And request for closing the case. Just a minute, huh? Record her presence also. Huh? Name, huh? I spread for land council for the petitioner. She is hearing me, huh? Or that was presence also. Yes. Item. 22.
May Lordship, please.
Okay. Yes.
An FIR was lodged on 3/6/2021,
Just a minute. 3/6/20.
3/6/2021,
Hmm.
and on the basis of that FIR, a case was registered by SIC, that is SIC Vigilance Case number 07. After investigation of the case, the charge sheet was filed on 18/5/2023. After filing of the charge sheet, again, a supplementary charge sheet was also filed. That is
Supplementary charge sheet also.
supplementary charge sheet. That
Okay.
is on 14/7/2003.
Okay.
Now, after filing of the supplementary charge sheet, it attained the finality of the investigation, and on the basis of that supplementary charge sheet, we come to know the sanction for prosecution was granted. After submitting of the charge sheet, the trial was begin, and on the basis of that sanction, I have filed discharge petition, and it was registered as 159 of 2023. Thereafter, two occasions case was fixed. And the date are one was on 19/12/2023, that is page 61. Page 61. Mrs. K. Bagra, learned SPP, is present and has submitted that against the accused SB above, the IO of the case has obtained the prosecution sanction by the state government, whereas at the time of offense, the accused was a central government employee. The learned SPP has further submitted that with regard to the another accused, Rilin Mulam, the IO of the case has not obtained the proper prosecution sanction as the relevant section is not mentioned in the sanction order. Therefore, the learned counsel has prayed that some more time may be given to her for obtaining the proper prosecution sanction through IO of the case. Then, Mr. Patil, learned senior advocate, through his junior, Sri Mukbam Patil, has filed a NIA registered as 189/2023 under section 227 of CPC with prayer for discharging the accused person Hingia Bengia above. Objecting on the application, the learned SPP has submitted that discharging the accused person without having the prosecution sanction at the stage will amount to taking cognizance by this court of the case, which cannot be done at this stage. Therefore, the learned SPP has spread to reject the application. The IA is kept pending till receipt of proper prosecution sanction by the IO. Now, accused SB Abu and Nilin such and such. After that, next date was fixed. Next date of the case is fixed on 15/3/2024. For receipt of prosecution sanction, if any, by IO of the case. Now, again, on 15/3/2024, accused SB Abo is present along with learned PGC's removed by M. Pertin, senior advocate, by Mubom Pertin, learned advocate. Accused Lilin Ngulon is absent. However, his learned PGC, Mrs. L. Lombe, is present and has spread for dispensing with the appearance of the accused on his personal inconvenience. Learned counsel has prayed to allow him to withdraw the IA 159/23. The same is allowed. Next date of the case is fixed on 7/5/2024 for receipt of prosecution sanction. For receipt of prosecution sanction. So this is the one of the when police is to pray before the court. Police has not prayed. Police has already submitted charge sheet as per section 173 of the CRPC. It attains the finality. And PP has sought time to furnish the valid sanction. Now, PP is not the part of investigating agency. PP is to place the record in the court what the IO has submitted. So PP cannot play the role of the investigating officer, or he should place as a role as a PP. Now, on the basis of this, my basic contention is that the sanction which was granted, it was granted, it is an invalid sanction. It was not granted by a competent authority. I, being a central government employee, my sanction should be obtained from the central government. That sanction, prosecution sanction cannot be granted by the state government. So, on the basis of that, since sanction was not granted by a competent authority, an appropriate authority, in that case, the proceeding of the case, in particular of the accused, may be what? Under section 482 of the CRPC. Now, prosecution sanction. Now, yeah. Prosecution sanction is page 41, Annex 3. And in the last para, that is para 5. Now, therefore, the government of Arunachal Pradesh hereby accord sanction for prosecution of Sri SB Abo, DFO Bandau Dua, and Sri Rilin Nulong, RFO Bandau Dua, for the offense committed under section 120 BIPC, read with section 7 of the PC Act 1988, or for any other offenses punishable under the applicable provisions of law to enable taking cognizance of the said offense by the court of competent jurisdiction. Now, this prosecution sanction was granted by Dr. Sarat Chauhan, IAS, Principal Secretary to the Board of Arunachal Pradesh, Department of Environment, Forest and Climate Change. This is granted by the government of Arunachal Pradesh. Whereas I am the employee of the central government. Now, I am serving as an Indian Forest Service, IFS. Since I am belong to the IFS, the prosecution sanction should be given by the central government, not by the state government. Therefore, this prosecution sanction is become invalid and issued by the incompetent authority Since this invalid, on the basis of this invalid sanction, the court cannot proceed. The
Court
proceeding.
cannot proceed.
Yes, now, now, section 19. What section 19 says? Section 19, prevention of previous sanction necessary for prosecution. No court shall take cognizance of an offense punishable under section 7. I have been charged under section 7. And 7, 11, 7, 10, 11, 13, and 15 alleged to have been committed by a public servant, except with the previous sanction, except as otherwise provided in the local and local sanction. Now, in the case of a person who is employed in connection with the affairs of the union and is not removable from his office, save by with the sanction of the central government of the government. That means I am working, I am serving as an IS officer, IPS officer. Since I am an IPS officer, I am belong to the central cadre. So state government has no authority to grant the sanction. When the IO has already been submitted, the charge sheet, and there is no any prayer made by the IO to the court that he will produce the valid sanction. And court is extended. And because of this delay, the DPC was held in the month of January, but my promotion cannot be considered. And because of non-clearance of the vigilance certificate. That's why I come forward to this court that on the basis of this sanction, the court cannot take that cognizance. Since court cannot take the cognizance, in that case, if any proceeding is done in the trial court, it said that proceeding may be watched and set aside.
So, according to you, the IO, whether the IO has kept open for submission of the supplementary charge sheet while submitting the charge sheet?
No, supplementary charge sheet can be submitted. He has already been submitted.
It was full and complete, Emperor.
Huh?
Submit to full and complete.
He has submitted the supplementary charge sheet and it becomes complete.
Whether the court has taken cognizance of the case?
Huh?
Whether the court,
Yes, court has taken the cognizance. And because of that cases.
where do we find that?
No, that are fixing. The order has been passed. That is, in order was passed on 15/3/2024, and order was passed. on
Where is the
19/12.
order that the court took cognizance of the case? Where is the order showing that the court has taken cognizance of the case? Or order of the court? Court normally, after submission of the charge sheet, if not yet taken cognizance, has to say, saying that received, charge sheet received, taken cognizance.
Yes.
Where is that order?
That order has not emerged.
Then not yet taken cognizance.
After taking the cognizance, he has fixed the date.
Now, where is that cognizance?
And unless the cognizance has taken, he will not take up the fix the date.
So can you just show me
It implied
the order
the
taking
19/12
cognizance of the case?
it can be
You
obtained.
said, because the order says, and you said that the court cannot take in cognizance of the case.
Yeah.
Unless sanction is approved.
Approved. But
Prosecution sanction is granted. I'm
granted. But here in the case, prosecution sanction has been granted. Here in the case.
But you said that there is a defective.
Yes,
It was issued by the incompetent authority.
yes, that is my contention
So,
is that
That's why I'm asking
Ah.
whether the court has taken cognizance.
court has taken cognizance.
Where?
That has not been annexed.
Annex? Challenge that one. You need to challenge the that
that-
order only.
Then anyway, notice may be issued and I
Okay.
will furnish it as an additional
Okay.
document.
Mandela fix lang kami.
Move button. Lauren, senior counsel, assisted by
Temper.
Lauren counsel for the petitioner. Para.
Hello, Lalini.
This is an application on a section 482 of CRPC 1973. Praying for setting aside and quashing the FIR dated 3/6/2021, charge sheet dated 18/5/2023, supplementary charge sheet and trial proceeding of PCA -02/2023 in SIC within bracket VIG vigilance and bracket close 07/2021 under section 120B IPC read with section 7 of PC Act pending before the Lana Court of, it should be at special court.
Special court,
Hmm.
UPA.
So it should be special court, Lana Special Court PC Act. Have you mentioned special court? Nowhere, I think. You have mentioned this to me. Pending before the district and session, just comes special court PC Act, UPR, in respect of the applicant. On the ground that there is no proper, there is no valid and proper sanction, a prosecution sanction
From the competent authority.
from by the from the competent authority. Stop. Issue notice. Returnable by 4 weeks. The
4 weeks.
how 3 weeks?
The special PP is not present today, so it may fix on Monday.
Need no present. Copy served or not?
Copies means, they mistakenly place it today, the PP is not, he'll be on present tomorrow Monday, on
Okay.
Monday. It may fix on Monday,
Okay.
coming Monday,
Okay. The
on 8th.
okay, then the PP is not present. The petition, line counsel for the petitioner shall take steps upon the respondent by the line counsel for the petitioner shall serve a copy to the line special PP. With special PP or what?
Special PP.
Or standing counsel SIC or what? Special PP or
Standing counsel.
Standing counsel.
In the High Court.
Okay.
Standing counsel.
Standing counsel SIC. During, when? Within 2 days. Start.
Monday.
Respondent competent.
Respondent. Yes, sir.
Only one only.
There is also one respondent who have made a party to the complainant.
Complainant also.
Complainant also.
And so far as the respondent number 2 is. Insofar as respondent number 2 is concerned, the petitioner shall take steps by a registered post with AD within 4 days from today. 4 days or 1 week?
1 week.
1 week from today. Then the fixing will be
Yeah,
changed. Least is matter after 4 weeks.
4 weeks, no, 2 weeks only, because we are, we are seeking an interim order also, after 2 weeks,
No. You have which interim, which one?
Uh,
You have not annexed. You have not satisfied the court by annexing that the court has taken cognizance. That will be taken up next week, next date. Okay.
I've got one more item, that is serial number 26.
26.
26. Very, very small case.
26.
26.
Connected.
No, not connected, and different case.
Then let the matter call.
I'm busy in other court also, that's the problem.
Yeah, okay. 26. Excuse the. Otherwise, all advocates are busy.
One case is coming here in the session. They're
So-
insisting me to come again. That's right.
So if we allow, then the advocate who stand here will stand for whole day, following his matter. Next time will not do.
Mhm.
Okay. Yes,
Yeah.
item 26. What is
26,
this
yes.
matter?
While the case of CRPC 10, 2024
This is
was,
IA.
yeah, was heard. Heard.
It was earlier, it was heard already.
It was heard. And an
IA is
order
for
was,
what?
an order was passed.
Okay, IA is for what?
I
Is for what?
only to allow us to take a substitute manner of giving service. The ground of the case is that on 27 it was ordered that we should take.
I think this is the matter, last time you tried to mention.
Huh. We were asked to take step.
Just a minute, you have received the copy? Yes. Okay, any objection? Hmm?
They can take dusty, no
Okay.
problem.
Hmm.
Apart from regular service.
Apart from regular service, I may be allowed to
Okay.
take the dusty service.
Mr. Mukherjee, Land Engineering Council, assisted by Miss. Also heard Mr. Pitapo,
I'm for respondent 1 and 2.
Land Council for the appearing on behalf of the
Respondent
number
1
1
and
and 2. Stop. Para. By filing this IA, the applicant prays for allowing the applicant submit that steps upon respondent number 3 to 23. 3 to 23 could not be taken as there was insufficient of postal stamp
Postal
in the
stamp.
post office. Could not be taken on time, due to lack of sufficient postal stamp
In the post office.
charges at the in the post office. Hence, pray for allowing the petitioner to take steps upon the said respondent by a dusty service along with the and then some of against some of the respondent you probably has taken steps already. No.
No,
This
only
is
to
apart from taking regular steps. This will
It's
be,
a regular step, the register
yes, that's a
by
regular.
register, it is
yes.
not possible. They say that postal stamp because it involves 12,000.
No,
It is not available.
it was not available in the. post office.
12,000 stamp service is not available in the post office. So that is why they are asking for taking by way of dusty service. And then apart from if we say then by way of the register service also, then again see, they will have a problem.
We'll take the dusty service.
This point number 323 are performer
no,
respondents.
there,
Service would suffice. They are performer respondents.
Which, who,
3 to 23.
3 to?
23 are performer respondents.
Okay.
Now,
No,
we will,
there, if you, Lordship sees para 7,
Hmm.
that is that prayer.
Yes. Allow the petitioner to take steps on respondent number 1 and respondent number 3 to 23 by way of dusty service in the dusty service.
Yes.
So dusty service only.
In addition to steps for service
Where
notice
do we
through
find?
AD, para 3, para 7.
Para 7. Then take steps all the respondent except respondent number 2 by way of dusty service. In addition to the step of service of notice through register. Okay.
Yes,
So you have
director.
said your prayer is
The AD has
okay.
already, AD
allowed
has
to take
already
steps upon the respondent number 3 to 23 by way of dusty service in addition to the steps
Yes.
in addition to the notice through register
Yes, because that's already ordered.
with AD.
Otherwise, we'll be reviewing the said order.
Stop.
That can be done.
The prayer is allowed. The petitioner shall take steps upon the respondent number 3 to 27, 23 by way of justice service, in addition to the steps, in addition to the steps of service of notice through registered AD is directed in the order dated 27/3/2024. So with the above this, and then the step be taken within a week.
No,
Before eight.
next date is
on the
8.
day.
Okay,
Only next date is
so
6.
within 2 days.
Yes,
okay, within
that's
2
why,
days.
that's why we're
Within
praying
2
for
days.
justice service.
Okay, with the above this, IA stands allowed and disposed of this. Okay. Two.
Your Lordship, on 27/3/24, there was a specific direction from this court to the accused to appear before the IO on 2nd of this month. However, Your Lordship, the accused didn't appear. This is the status report.
The accused did not appear.
Yes, Your Lordship.
Lord.
And this is not for the first time, in many occasions, Your Lordship. 1, 2, 3, 4, 5.
May I,
Almost in-
Lordship?
Yes.
I'm on behalf of Titaba. As per the order, the accused person, alleged accused person has tried to appear before the IO, but because of unavailability of IO, I haven't appeared.
But,
Later,
but it seems that this is the report by IO.
Yes, Your Lordship.
What the IO says
IO says it didn't appear, Your Lordship.
did
It
not appear.
Did not appear. In the last, Your Lordship, line is written, there is a direction from this honorable court to appear before the IO on 2nd for 2/4/2024. 2/4/2024.
Where?
Your Lordship, the last order, Your Lordship may kindly see the last order, 27/3/2024.
Yes, 27.
Yes, it's written, hard C, learned counsel for so and so, hard Miss T Gini, so and so, list matter on 4th, so and so. In the meantime, the applicant is directed to appear before the investigation officer on 2/4/2024, failing which
Before we appeared,
not appeared, Your Lordship.
appropriate orders shall be passed.
Yes, sir. It will be amounting to disobedience with this court order, Your Lordship. Condition violation.
So he is protected by the interim.
Yes, Your Lordship.
Okay. So when he was this order was January,
Yeah.
and since January, the IO, according to you, is absconding.
last, on 4th March.
I think there are so many orders.
Yes, 4th March
He never
2024.
appears.
In many occasions, order was passed to appear, and ample of opportunity has been given by this honorable court.
It appears, it appears.
And ultimately, at last, on 27, that order was given that on 2nd, again, he has been given opportunity to appear. But as per the status report, the accused didn't appear, Your Lordship.
You see, you just see the order 16/2/2024. It was also directed to appear before the IO on appear before the IO on
On
19
yes.
and 21.
Yes, Your Lordship.
And then says
19 to 20, accused.
it is made clear that if the applicant does not appear before the IO as directed in this order, the pre-arrest bail granted on 19/1/24 and the subsequent order of extension shall stand automatically cancelled. He did not probably appear.
Yes, Your Lordship.
What prevent you from arresting? What prevented you from arresting?
Your Lordship, it's not about arresting that accused and all, Your Lordship. It's about the anticipatory bail. The privilege has been given to that person.
No. Thereafter, you automatically stand cancel, it says.
Your Lordship, but Your Lordship may
After cancellation, you had an opportunity to
Your
arrest
Lordship
him.
may kindly see on 27/3/2024. There is an order from this honorable court, the latest order, Your Lordship.
No. So here, my query is that after this order, if he failed,
Yes, Your Lordship.
what prevented the IO from arresting him? He could have arrested.
Your Lordship,
He doesn't require.
Yes.
IO doesn't require this.
Your Lordship, here is a case. It's an anticipatory bail. And Your Lordship, it is well settled that even if the custodial interrogation is not required, it doesn't mean that person is entitled for anticipatory bail. But the question here is, Your Lordship, in many occasions, he has been given ample of opportunity to cooperate with the investigation by virtue of the order passed by this honorable court. And there is no any express direct order by this honorable court stating that the bail is then cancelled. Ample opportunity has been given. They have made a prayer. And basing on that, Your Lordship, the IO has also not acted upon or not
Yes.
arrested the accused, Your
Yes,
Lordship.
it appears.
Yes, Your
Because
Lordship.
IO had also an occasion to arrest him. IO also is not interested to arrest him, and then he is also not interested to IO.
But yes, Your Lord, the question here is, Your Lordship, this is an anticipatory bail.
And then both are playing with the court.
Your Lordship, we, in fact, the IO is not playing with the prosecution side is not playing with the court. The question here is, Your Lordship, this is a pre-arrest privilege bail, Your Lordship. That has been on prima facie satisfaction. This honorable court has granted bail.
Yes.
Now, Your Lordship, this is well set. It is well settled that even if the accused is not required for the custodial interrogation, he is not. The accused will not directly automatically get anticipatory bail from this honorable court, because Your Lordship, the principle has to be followed that whether he is cooperating with the investigation or not at this stage or not. And Your Lordship, at the investigation stage, if there is no any interference by this honorable court, by supposedly, Your Lord, not interference by this honorable court, it is the investigation authority. If the investigation authority find it necessary to take him in the custody for custody interrogation, then it is upon the investigation authority to decide whether he has to be taken into custody or not. But here in this case, since he has been protected, and because of this protection, he is not appearing. And the investigation authority cannot go directly and arrest the person, Your Lordship.
No, that is why I'm saying that rightly or wrongly, he was protected
Yes,
by
sir.
an order dated 9/1/24.
Yes, Your Lordship.
But an incident has, by an order dated 16/2/24,
Yes, Your Lordship.
it clearly says that even only if he failed to appear on this date, the bail granted on 9/1/24 will automatically stand cancelled. Automatically stood cancelled only thereafter. Huh?
Yes.
That is why
Yes.
I'm saying that if the IO required him, for custodial interrogation or even for examination, recording of 161 also, would have arrested him.
But
If he required this accused
Your Lord,
person.
there is also one situation is also there. He's absconding, Your Lordship. It is not a case, Your Lordship, the accused is sitting there somewhere and accused can directly go and arrest. He's not cooperating as well as he's absconding. That is my humble understanding so far as, Your Lordship, the status report is concerned. And the ample of opportunity has been given by this court, honorable court. And last chance has also been given as reflected in 27/3/2024, that without failing on 2nd of April, the accused should appear before the IO. That is again not complied with the accused, Your Lordship.
Never appeared. Not-
Initially he appeared, Your Lordship.
Okay, then what you want?
Initially appeared, but Your Lordship, he has failed to disclose the person. He has not disclosed the person from whom he has taken the check, Your Lordship.
There we don't know. You can't compel.
No, that is there, Your Lordship. That was the initial contention. But after that, there was many development, Your Lordship. Initially 161 was recorded. He has stated that basically the allegation was regarding, Your Lordship, forced signature of the Deputy Commissioner.
Yes.
So, Your Lordship, basing on that, 161 state was given. He has stated that one person from the DC office has given the check. So, for the purpose of, Your Lordship, investigation, considering the fact and circumstances.
Then that means he required a custodial interrogation is necessary.
Yes, Your Lordship.
That is why I'm saying if he is required, what prevented IO after cancellation of the bail?
Your Lordship, bail was not
Then-
cancelled, Your Lordship. Till that bail was not cancelled, Your
No.
Lordship. Not cancelled, Your Lordship. Not cancelled, Your
Just
Lordship.
see this order.
That is not the cancellation order, Your Lordship.
No, 16/2/2020.
Yes, Your Lordship.
And the subsequent order extension said stand automatically cancel. The same judge who passed, I think probably.
Then, Your Lordship, then subsequent order will be amounting to review its own order, Your Lordship.
No, thereafter you did not do anything. And then the case came before this court again, and then they made a prayer, probably then extended again. Because you did not act.
Your Lordship,
on
there
time
is
when
except
you had an opportunity.
Your Lordship, that person was absconding, Your Lordship. If he appeared, then what prevent him from appearing before the IO?
Beyond reach of the police. you
Yes,
see.
Your Your Lordship, there are many
And
circumstances. Your,
Cognizance,
Your Lordship, basically, when interim order is passed by this court and the matter is not disposed of, it becomes difficult for the investigation authority to, Your Lordship, act it upon, Your Lordship. And this matter was pending, Your Lordship. During the pendency, that observation was given, Your Lordship. It was not disposed of, Your Lordship.
Okay. So what do you want? What do you want?
Your Lordship, that order has been, in fact, has been violated, Your Lordship, the 27th
ah.
March. Then he's
Even
not,
if it is cancelled also, you will not go to arrest him.
Your Lordship,
Then-
if Your Lordship, what my humble submission would be, Your Lordship, it is a clear disobedience of this honorable court order, Your Lordship.
Hmm.
So privilege has been given. It's not a case where he has not been protected, Your Lordship. He was protected, given an ample of opportunity to appear before the IO. In disobedience of this honorable order, Your Lordship, he is still not appearing. So he is not entitled for any interim protection, Your Lordship. Let the investigation agency decide whether he has to be taken into custody or not, Your Lordship.
Hard miss?
Lordship, last chance may be given.
What last?
Or-
All or last chance only?
Last chance
Lordship,
will never be last, Your Lordship.
How many last chance?
The
Is
IO will
last
be
to last-
available after 15 of this month.
I think last to
Could
last
do.
chance was also given. And then thereafter what? We do not know. Difficult, see, and then court has been passing order. Police not acted on time. But then, okay. Hard miss,
En hondik.
you are miss,
En hondik. En hondik.
huh?
En hondik.
Okay, then counsel for the applicant. Also hard miss, Mr. Ete, PFA, then counsel, then additional public prosecutor for the state of Arunachal Pradesh. By in order dated 9/1/2024, the accused Shri G. Panyu, Gita Panyu, was granted interim protection with certain conditions. While granting this interim anticipatory bail, whether he was directed to appear before the IO. So this is in the event I say, and it seems not directed. No?
Yes.
Thereafter, I think it was directed.
Yes.
Started directly. No, he appeared
Yes,
immediately thereafter.
yes, your lordship.
He appeared. And in his statement under 161 also
Yeah.
already.
Initially, your lordship,
Yes.
very initially. Later on, your lordship, he didn't cooperate.
So if required, you may, you file an application, miscellaneous application, IA for cancellation if you want. So since he has already earlier appeared, and only because he is not giving a disclosure statement, we can't do that.
Your
Court
lordship,
cannot give that direction.
what my humble submission would be, your lordship, this was the observation of this honorable court, your lordship. It
appropriate
was not
order
my
of the
submission, your lordship.
Hmm.
This honorable court find it necessary to direct him to appear before the IO.
Hmm.
That for that reason, your lordship, he was directed to appear before the IO to give his further statement, your lordship, on the direction of this honorable court, your lordship. And he has not complied with it, your lordship.
Because it appears that he is required to be interrogated. So you make an application, appropriate application. If the IO required him for interrogation, because for that he need a permission.
Your lordship, if suppose this bail is granted, he's been granted bail.
Bail will not be granted, bail already granted.
That was interim protection, your lordship.
Hmm.
That's interim protection, your lordship.
Now either to make it absolute or to extend.
Either absolute or your lordship reject, your lordship.
Hmm?
Either
Yeah,
absolute,
reject.
yes,
Hmm.
or reject, your lordship. If absolute, your lordship, if in future, if required, we'll file an appropriate application for vacation of the same, your lordship. Still that he is in nobody's custody, your lordship.
Hmm?
As on today, he is in nobody's custody, your lordship.
So we'll give you one more chance. Because on 19 also it appears. Hmm? The IO himself says that accused Mr. So-and-so appeared before him on 19 also. It appeared. And then he was interrogated
Yes, your lordship.
on 19 also. So one more chance can be given with the direction to appear. And then this time IO should take note. Then IO should act. Hmm. Okay.
Your lordship, so far as my humble understanding is, your lordship, if your lordship allow him to give him further chance, your lordship, without your lordship giving any observation to the IO to act upon or to arrest that person, your lordship, because this is an anticipatory bail, your lordship.
Same condition that in case he failed to appear, it will stand cancelled.
Then
Automatically.
then again, your lordship, the matter will remain pending, your lordship.
During that cancellation period, you can arrest him.
Okay, your lordship, but your lordship, that will be very difficult for technicality will come up, your lordship, because this anticipatory bail
You
application.
want the accused to, you want the court to bring the accused before you, the IO.
No, your lordship,
Brought it before the
I'm
IO.
not,
No.
I'm.
It is the duty of the IO to go and arrest.
But your lordship, the question, anticipatory bail, interim protection
No,
has been
no,
granted.
what I'm saying, in the gap period. So now also I will give.
Your lordship has already seen, your lordship, there is an order in 16 or 19 saying that, your lordship, it will be automatically cancelled. But your lordship, even after that, your lordship, the court is giving an opportunity to the
Well,
accused.
thereafter the court came and then you did not arrest. Had you arrested, had the accused been arrested, then the matter would have, the cancellation order would have stand.
Then your lordship, in that event, your lordship, this case was supposed to be disposed of on that day, on that day itself, your lordship, when the condition was violated, your
Came
lordship.
before the another judge.
Without your lordship, then in that case, without giving any other observation, just your lordship give them the last chance and make an observation that if he failed to do so on the next date, your lordship, the state will have the liberty to pray for your lordship cancel this discontinue of the your lordship recall of the interim protection, your lordship.
Miss. Her name. Praise for. So on second also he did not appear. Miss her name, huh? So you are Miss
N. Hondik.
submits that as per the direction of this court on 27/3/2024, the accused. You said that the accused appeared before the.
Yes, actually accused has tried to appear before the IO, but there was no availability, because of no availability of IO at that time.
Try to means you did not appear.
Uh,
How do you know? You did not appear before the police station.
Statement has already been given. Later,
No,
as per
that was earlier. That was earlier on 2/4.
At least, your lordship, what my learned sister can do is, on the day when if he or she appears, he can make an
Yes,
application
yes,
before the
attendance,
concern.
attendance,
Yes,
attendance.
attendance can be given, your lordship.
On 4. Okay. The accused tried to appear before the IO. However, as the IO was reported to be out of station, the accused did not appear and prays for giving him another chance to appear before the IO of the case. Stop. The Lanet PP submits that the accused is deliberately avoiding appearing before the IO. Hence, the interim anticipatory bail granted to the accused on
9/1/23.
9/1/2027 may be cancelled. Stop. Para. Considering the submission made by the land counsel for the petitioner, the accused is given one more chance to appear before the IO of the case. And the accused one more chance and directed to appear before the IO of the case on. So when? Monday or
On or before 11th, your lordship.
okay, on or before 11. On or before 11, we'll give a date only.
Okay, your
Okay,
lordship.
on
On 10th,
okay,
your lordship.
on 10 April 2024, failing which 2024, stop, Fair, stop, It is made clear that in the event of the accused failed to appear before the IO as directed on 10/4/2020, the pre-arrest bail granted to the accused on 9/1/2024 and the subsequent order of extension shall stand automatically cancelled. Appear, but he was not arrested.
Not arrested.
I should have arrested. List this matter on.
Your lordship, this small observation, your lordship, in automatically cancel and IO will be at liberty to arrest if so required, your lordship.
In which case the IO has the liberty to arrest the accused. They take action against the accused as per law. Let's say, no,
Yeah.
stop, huh? Please this matter on after vacation, I think 22.
Yes, Your Lordship.
22.
Your Lordship,
The, 22,
uh,
on which date? The
let updated.
Alana additional PP shall produce the updated CD.
CD. Your Lordship, that status
Next,
report.
Your, huh?
Your Lordship, that status report may be written.
In the meantime, the interim the interim anticipatory bail granted to the sorry, the accused shall remain extended. Huh?
Remain
Till then, huh?
Extended, Your Lordship, subjected to the condition
No, no, till 10.
till 10th. Okay, Your
Till
Lordship.
10, huh?
Your Lordship, status report may be written, Your Lordship. It is a part of the case diary, Your Lordship. Deeply obliged.
My Lordship.
Yes.
Lordship, this is a regular bail application under Port 39. For the offense arising out of ITA WPS case number 115/2023, registered under section 350.
Your Lordship, for the amount, 26 gram come under the 21B.
Let us see the FIR, huh? How it.
Yes. Your Lordship may come to page number 11. It is to inform you that today on 3/11, upon receipt of input from reliable source regarding transportation of drugs from Assam to Itanagar, a police team led by me along with the executive magistrate.
Okay, so the Naka was there and he did not stop there.
Yes, he did not stop.
He
there.
along with his associate started running
Yes, Your Lordship.
and later on court hall.
Yes, Your Lordship, the fact why he did not stop there was he did not. I did not know anything about the contraband that was
The why
present in
you
my.
had to run?
Your Lordship, I was arrested in another case also, in NDPS case.
Okay,
And it was been only 4 days since I was in bail. And after that, I was told by,
that shows that you are habitual.
no, I'm not habitual, Your Lordship.
Okay, then
Because
but
I was never-
you said that you were just released
Yes,
4 days back.
I was just relieved. Your Lordship, after just releasing of the, after releasing from judicial custody for 4 days, I would never do such activities in just 4 days. I was told by my master to go with Rajat Ali to Itanagar. Since the Rajat,
Same master who sent you earlier.
not in this instant case,
Ah.
from whom I was working as a butcher in the butcher
Yes,
shop.
yes, that is why I'm saying.
Yes, the same master.
Okay.
And since
Then
the
you
Rajat
see-
Ali, the co-accused,
Ah.
he could not drive. That is why he gave me the car key to drive him to Itanagar. That was the only
You are the
reason.
driver.
Yes, I was the driver. And
Okay, the main accused is,
the Rajat Ali, from whom the contraband was
his bail
found.
is also there? No. Has he
He-
applied for the bail? No.
Yes, he is already enlarged on bail.
The main accused is on bail.
Yes, Your Lordship.
On what ground?
On the ground that IO has not specifically mentioned the actual weight of narcotic drugs as 26 gram is in gross plus weight of 2 showcase. Your Lordship, if we subtract the weight of 2 showcase, then it may come
Have you
under.
annexed the bail granted to the main
Yes.
accused? Where?
Yes, Your Lordship.
Let us see.
Your Lordship may come to page number 16, Annexure 6.
Granted by the special judge.
Yes, granted by the special judge.
So why you did not apply there then?
Your Lordship, I
Claiming
applied.
clarity?
Yes, I applied there,
Ah.
and the honorable judge, the session judge, was about to take this matter after the CC, because CC was just nearby when I applied bail, and CC was supposed to be taken on the March 1, Your Lordship, and on that particular week, the session judge was on training, and the matter has been postponed to the April 30, and there is disparity of 60 days, Your Honor. Your Lordship.
Hmm.
So when again on the 7th of the March, there was final bail hearing again in the session court, but session judge was of the opinionated that the bail should be granted after the CC. But
Okay.
CC was supposed to happen in March 1, Your Lordship. That
Now
is
CC
the-
done?
Huh?
Now
No,
CC done?
CC is pending for April 30, Your Lordship. Your Lordship,
So
60.
why you did not file subsequent bail application before that court?
No,
Because the same court has released,
yes.
and this court might not have that, you see,
No, no, in Your Lordship,
will not be
when-
liberal like the session court or the special judge.
Your Lordship, when the last bail hearing was heard, and the order was passed that the bail will be taken after the CC. And virtually, we cannot apply any more bail application in the session court before the CC. And CC is fixed for April 30, Your Lordship.
This was filed when?
And
Yes.
and
Just a minute. Hmm.
7/3/2024, before the special judge, where was this paragraph 5 that was it? It is
Before the special judge,
Yes, Lord.
page,
Page 15. Last order. 7/3/24,
okay.
where was it, this special court has rejected this bail application.
Oh, this was subsequent bail application. You have filed not only one, but subsequent bail application also you have filed already. It was also rejected. On what ground? That he is.
This paragraph 4 is wrong, Lord. Here the charges.
Your Lordship,
Ground for granting the. No, I think it was a default bail only, default bail rejected. Default bail rejected.
Your Lordship, the charge sheet was already filed.
No,
I
already
was
filed.
Yes.
Then can't.
I was-
Then why you did not file a regular bail?
Yes, I was
Bail under
not
439.
known about the charges has been filed. So that is why I.
No, thereafter subsequently you could have filed bail under, could have made prayer before the session court to consider bail on merit on 439. Or could have filed a subsequent bail application for his release. So, no, this was under 167. Claiming for release on expiry of the statutory period. Subsequent bail application under 167. So that is why I'm saying that because you made a prayer for release of the accused on expiry of the statutory period.
But it
And then since by then, the charge sheet, the learned special judge found that the charge sheet already filed before you filed this bail application. That is why it was rejected.
Yes, Your Lordship.
Then what I'm saying is why you did not file subsequent bail application under 439 for considering the bail on merit.
Yes. Your
Because claiming parity that the co-accused, who is the main accused in the case, has
No,
already
Lordship,
released.
actually main accused, this applicant is the main accused.
Oh,
That
this
was,
is main
Lordship,
accused.
that was the co-accused,
No,
Lordship.
Your Lordship,
He
the main
says that
accused.
No,
he
Lordship,
only
can you
accepted-
go through the Lordship, this
Main
order,
accused is
Lordship?
Rajat Ali. No seizure memo is there from the.
Lordship,
Your Lordship, no seizure memo is there. Nothing has been recovered. I was just implicated on the statement of the co-accused. And Your Lordship, I have case laws.
Statement, you have a statement also.
Yes, I have.
What he stated,
He stated
who was arrested earlier?
earlier that Rajat Ali was arrested.
You were-
Co-accused was. I was not arrested earlier.
On that day, although you were present, you were not arrested.
No.
But you absconded, I think you ran away.
Yes, on that very moment, since I was only
Why you did run away?
since I was on the bail for only 4 days
So,
from the previous case.
see,
Your Lordship.
you are showing the contradictory things. One way you are showing yourself that you are the one.
No, Your
And
Lordship,
you also says that you were still serving with the same master,
yes, Your Lordship,
same master.
I
with
just
whom,
followed.
because of with whom you were arrested, and then just 4 days before you were released. And with the same master, working for the same master, you knew it.
No, Your Lordship, the co-accused is not my master.
No, the one who engaged.
Yes, the one who engaged.
Who engaged?
We
Who
both-
gave you key? Who
Yes,
gave you key? The same master.
yes.
With
So I had to follow the order of my master. That is why I went.
earlier also you followed the master's order and you got arrested. Why you had to follow again? I
No,
think
in only one instance.
so.
Your
In
Lordship.
the rejection order, on merit, on what ground?
Your
Reason?
Lordship, may there is the 161 statements of both the accused and
Oh, so this is 437. Bail granted under 437. How could the special judge or the session judge?
it should have been in 439.
Relates to 439. How could? You file bail application under 437 before the session judge?
No.
Can't.
It's for the magistrate. Your Lordship.
You can file bail application under 437 before the magistrate.
Mm.
But then
This
this is
is-
before the special judge or the session judge. It has to be under 439.
This bail application, NSR number 6 is for Rajat Ali, co-accused. This bail order. Bail
Yes.
granted order.
It was granted under 437.
Yes, Your Lordship, there is no reason to keep me in the judicial custody for.
Where is your, the first bail rejection order on
But-
merit?
First, bail was never rejected on the merit, Your Lordship. The first bail order was rejected since I did not annex the original authorization copy. First bail application, Your Honor, Your Lordship may come to page 4, para 6. The first bail application has been rejected by the Lana Session Court on order dated so and so.
What is this? Page 13 is whose bail application?
Page number 13.
Your name is, the accused name is here?
Jiabur Rahman. I am Jiabur
Jiabur.
Rahman, Your Lordship.
Okay. Okay, this Noor Muhammad file petition for whom? For release of? What is
Your
the
Lordship.
name of the accused?
Yes.
No, he is a habitual offender just after 4 days of his release.
Your Lordship, I was never convicted in any of such offenses, so cannot be termed as habitual.
Okay, so since the co-accused has already been released, I think he deserves.
Lordship, actually, Lordship, page 17, para 6. Where this co-accused who was granted bail, Lordship, his statement was there, Lordship, he accompanied Jaibur Rahman, this is the present applicant, after meeting another peddler of drugs, Sri Joinal Islam, who gave them 2 soft containing suspected heroin. Accordingly, they are traveling to Itanagar site for delivering the consignment to the drug users. And Lordship, after Lordship, the incident, Lordship, when the police has Lordship arrested Lordship, this co-accused, he fled the Lordship, the place of occurrence. And Lordship, later on, he was arrested
Lordship,
from
it
the
was not
Assam,
after
Lordship,
the
Assam
arrest.
police, Lordship.
Hmm?
He was later arrested from the Assam Lordship by the Assam police.
Oh,
He
he-
fled away from the place of occurrence. He's absconding, and later on, this state police arrested him from Assam on the from Assam Lordship, because Assam police have arrested him Lordship for the another case Lordship, which is registered there, 341 Lordship to the 23 under section 319 IPC with Arms Act.
Hmm?
Lordship, he was later arrested by the Assam police
Huh.
from Assam
In
Lordship.
connection with the arms act,
Yes, Lordship, connection with Arms Act.
involvement in
And
the-
after that, later on, Lordship, our Arunachal police, he brought him before the session court Lordship. So now he's under here Lordship in the our state Lordship in the custody Lordship.
Your Lordship, in this matter, I believe we should discuss in the instant case only, not the previous cases, Your Lordship.
During the investigation, it revealed that Lordship, he was a Lordship peddler Lordship. He occasionally Lordship sold the drug within the capital with the help of one
Wait,
Joydul.
wait.
I mean,
Wait, bro.
there is a charge sheet Lordship. It's in the record. He's not NS in the his petition to charge sheet Lordship. It is in the record. You will find the charge.
Where do we find that?
Lordship, in the record Lordship.
Hmm?
Your Lordship, even if the statements has made by the co-accused, if it does not indeed come within the definition of evidence contained in section 3 of the Evidence Act, Your Lordship, it is not required to be given on oath, nor in the presence of the accused, and it cannot be tested by the cross-examination, Your Lordship. The
Hmm?
co-accused, whatever the co-accused has deposed in the police station, in the absence of me, Your Lordship, I was not there to defend myself. And Your Lordship, here,
No, you see,
One
on the
fifty.
incident, when the Naka was by the police, no? Naka conducted at that time, the co-accused was arrested, but then he fled away. You fled away. And then you could not be traced out. And
No, you-
long after that, you were traced out and arrested with the help of the Assam police, as he submitted.
no, Your Lordship, I have,
And then you yourself have submitted that you were just released just 4 days back in connection with another similar case. And then when he was arrested from the Assam, there also he was involved with another case, involved with the Arms Act also. So that means he is a habitual. We are not on that, of course. But then you see, the conduct of this accused who fled away would not be traced out, absconder, you see. So it's very difficult to get him, we get such person to again for trial. So let the CC charge be considered, and after that, of course, if there is, then of course you can make a fresh bail application before the state court.
Your
The
Lordship-
state court will consider.
Your
So-
Lordship,
Huh.
I have reasons for my absence. I have reasons for my absence. Why police couldn't be traced out? have, IO could have like sent some 41A notice in the scope of the journal Abdin also of my
Right.
master. But such notice had never
I
come.
appreciate, but then you see, under the affecting circumstances, it will be difficult. And if you want that, the charge sheet already, when it is fixed for consideration
April
of charge,
30, Your Lordship.
April 30.
Yeah,
I think you better take chance after April 30. This will be rejected.
Your Lordship, it has been 238 days since.
Maybe, but then under the
And-
circumstances, affecting circumstances, and when the statement
And
against him, there is a incriminating material, you see, the
no,
material
there is no incriminating
no,
material in the instant case, Your Lordship.
during course of
Your Lordship,
investigation.
if I have to stay in the jail, then the co-accused from whom the contraband has been found, he also deserves to stay in jail, Your Lordship. Your Lordship, it will be, if I was acquitted after a trial, it will be grave injustice to me.
No,
Your
no,
Lordship.
don't base on that. Only because your co-accused, and since I'm here, your co-accused should also be arrested and be with me. No?
Your Lordship.
So that will be difficult.
Your Lordship, the sound bail will be provided and
Rightly or wrongly, he was released, but you could have immediately you could have also made prayer. What I'm saying, could have considered your bail application.
and Your Lordship, what the statute say
This
in
last paragraph you are showing,
Lordship,
which one?
Lordship, middle
Right,
one, yes,
last
Lordship.
paragraph.
Lordship, no, second, Lordship, I have,
Second.
next, Lordship, during interrogation, Lordship.
He is a supplier.
Lordship.
His name is
Jiabur Rahman. Your
Jiabur
Lordship.
Rahman.
Your Lordship, whatever material is available, it do not justify arriving at the conclusion that I should be in jail for so many days.
Individual shows right in eternal capital. With the help of Jiabur Rahman, with your help only. So, it will be rejected only, huh?
Your Lordship, Your Lordship,
NPS case, little
Your
problem.
Lordship kindly may come to the 161 statement
Hmm?
of the. Your Lordship, there is no merit to reject this bail only.
How?
In instant
There is
case,
a
Your
material
Lordship.
against him.
Your Lordship, I want to cite some case law, Your Lordship.
So they
Your
knew
Lordship, the
that
offense
there is a
alleged,
very
no
drug
doubt,
consumer
in
also.
in the case Prabhakar Tiwari versus State of UP, 2020, the apex court said that the offense alleged, no doubt, is a grave and serious, and there are several criminal cases pending against the accused.
No,
This
not on
factor-
that, not on that. We
by
are not
themselves-
consider on that.
Yes,
No, it will be rejected, not because he is involved in some other case also, because
sir.
there is a material against him here.
Ye-
And he's,
Your Lordship, there is no cogent materials against here. Your Lordship may read the 161 statement. Your Lordship, here
who's 161 statement?
of the Rajat Ali, Your Lordship.
Rajat Ali is co-accused.
Yes, Your Lordship. The co-accused from whom the contraband was found. And Your Lordship, the underlying statement. Your Lordship, the questionnaire, in the questionnaire, now Jainal Abdin and Jiabur Rahman are also present here.
Hmm?
They called three of them in the, they called,
Jainal Abdin,
and Jiabur Rahman are also present here. You tell me, who gave you the drugs on 3/11/2023 in Assam. Did Jainal Abidin give you the drugs? No, Jainal Abidin had not given me the drugs. The drugs were in the car where I entered the car. And your lordship may
Who
come to
gave
the,
this statement?
this Rajat Ali.
Oh, you are
I am Jaibur Rahman.
Jabur.
Your lordship may come to the
But then
question.
you drive the car
Yes.
and then it was in the vehicle.
Yeah, your lordship may come to the question number 7, your lordship. Next page, please. Kindly, your lordship. Your lordship, why did Jainal Abidin give you the car key? He was the one who asked the car key also. I told him that I wanted to go to Itanagar for some personal work. I was working at his house as a laborer at that time. So he gave me the car key and Jabur Rahman was asked to go with me. Asked to go with the Rajat Ali. He was asked to go with. He was neither intended, he was nor had any plan to go to the Itanagar on that particular day, your lordship.
Car key was given to the Jainal.
Yes, car key was given to the Jainal Abidin. And after that,
But you drove the car.
yes, I drove the car because the Rajat Ali, he did not know how to drive the car. And your lordship, this is the 161 statement of 161 statement of Jainal Abidin. Your lordship. Your lordship, in 161
Who is
statement of
Jainal Abidin?
Jainal Abidin is the master of both Rajat Ali and the
Okay.
Jabur Rahman and me. Your lordship may come to the paragraph 2. Rajat Ali usually worked in the Itanagar before working with me. I knew that he had some balance to get from one of the locals of Itanagar. On 3/11/2023, Rajat Ali requested me to give his car key to go to Itanagar. Since Rajat Ali himself could not drive, I gave my car key to Jabur Rahman and told him to go to Itanagar with Rajat Ali. He was told to go to the Itanagar, your lordship. Both of them left in the morning. After that, I don't know what they had done. And your lordship, Jabur Rahman I was nowhere intended to be in that place, in that car, at that very time, at that very moment, your lordship. It was totally out of my control.
Hard, Mr.
Mr. D. Nime, your lordship.
D.
Nime.
Learned counsel for the petitioner.
Lordship, may
Miss
Lordship.
H. Lakshmi.
Lordship,
Learned
at this stage, Lordship,
Director of
may,
PP, Government AP. Yes.
Lordship, at this stage, may Lordship may see the Lordship, while considering the bail, Lordship, at this stage, Lordship, the nature of the seriousness of the offense, and Lordship, the character of the evidence or circumstances, Lordship, which was peculiar to the accused, Lordship, and the Lordship, likelihood of the accused, whether he will fleeing the justice or not, Lordship, later on after getting the bail, Lordship, and Lordship, moreover, the impact of his release, Lordship, may make on the prosecution witnesses. Lordship, now trial is just begun, Lordship, and Lordship, next date is fixed for consider some charges, Lordship. So the at this state, Lordship, bail may not be granted, Lordship.
Your lordship, if the sound bailer and the sound security is provided, then it would not be justice to keep the accused inside the jail for the apprehension of.
This is a bail application filed under section 439 of the Criminal Procedure Code, 1973, praying for release of accused Jabur Rahman, who was arrested, who has been arrested by the Itanagar police in connection with the ITA PS case number 270/2022 under section 21B of the NDPS Act 1985 within bracket 985, arising out of the FIR dated 3/11/2022 lodged by DSP Kengo District. Stop. The case of the petitioner is that basing on the written FIR lodged by one Kengo District. Who is the police has registered the Kengo District, huh? inter alia, Kengo Duchi, inter alia alleging therein that upon receipt of the input from the reliable sources, the police, along with the executive magistrate, had established Naka checking at 6 kilometer Itanagar on 3/11/2022 at around 10:30 hours. Stop. At that time, a vehicle bearing registration number is 07 U dash 0148 arrived, and upon sensing that police present, the driver did not stop. You see, you were the driver and you did not stop. Did not stop the vehicle and ran away from there.
Yes, Your Lordship, out of panic, at the very moment only the co-accused told me that he is possessing a drug. Just a few seconds away from the Naka point. On that moment only I knew that the drug was there with the co-accused.
However, one accused, Rajat Ali,
And Your
was
Lordship,
arrested.
Rajat Ali was the one who instructed not to stop the car. The co-accused was the one.
And upon search made on accused Rajat Ali, heroin within bracket drugs in powder form packed in 2 plastic soap case containers weighing around 26 grams were recovered and seized from his possession. Basing on the said FIR, Itanagar PS case, the above Itanagar PS case being number 270/2022 under section 21B of the NDPS. Act 1985. Start. Earlier, the accused applicant has made bail application before the learned special judge NDPS. However, the said application was rejected. But the bail application. No, just a minute, Before that, and the accused was arrested. When he was arrested? After the registration, And the accused
10/8/2023. 10th August 2023. 10th August
8/2023. And since then, he has been lost under the judicial custody, police/judicial custody. Start. Who filed bail application earlier? the Rajat. He
Yes,
was granted earlier,
yes, Rajat
and
Ali.
thereafter you filed,
Yes,
but your bail was rejected.
yes, Your Lordship.
Okay. Earlier, earlier, a bail application was moved before the learned special judge NDPS for release of the accused. However, the same was rejected. When it was rejected? By 1312. This is not, this is for Rajat. Your bail was rejected, oh, no, okay.
Your Lordship, on
7-3 Lordship.
You are
last
not an
bail was
exact one,
rejected.
rejection
Yes,
of
7-3, 24.
7-3-24.
No, this is
Last bail was rejected on
7-3.
7-3. And the first bail was rejected on Your Lordship.
13-9.
First bail.
First bail,
13-9.
13-9-2023.
13/9/2022. Stop.
Yes. Different counsel was there.
However, the bail application of the co-accused Rajat Ali. No, just however, the co-accused Sri Rajat Ali has been enlarged on bail on 13/12/2022.
On 13/12/2022.
It is submitted. Hence, the petitioner is claiming parity. The petitioner prays for release on bail on parity. Stop. It is submitted that the case. It is submitted that after completion of investigation, the IO of the case has already submitted charges and no custodial interrogation of the accused is required. So, it is further submitted that it is further submitted that the accused is ready to furnish adequate bail and to cooperate with and to appear before the IO or the court as in when called for. So, Miss L. Hage, learned additional PP, while objecting, the bail submits that the accused is a habitual offender. He is involved in similar case in Arunachal.
Lordship, Arunachal also Lordship, before Lordship, this
have a
incident
number?
4 days before Lordship. Lordship,
Earlier
here,
also he was arrested.
Lordship, yes, Lordship. In the
Arunachal?
NDP, yes, Lordship, NDPS, Nahalagan PS, Lordship, just 4 days prior to this.
Connection with Nahalagan PS
Yes,
case
Lordship.
number.
Number is not given here, Lordship.
Okay, Nahalagan PS.
Yes, NDP.
Okay.
It is Lordship, this learned PP Lordship in the trial court, the session court Lordship, there she has submitted Lordship in the paragraph 4 Lordship. In page 14. That the accused is Lordship just after 4 days of his release by the Nahalagan PS in the NDPS case, the accused committed this instant case. And when the police tried to apprehend him and called accused Rajat Ali, the accused ran away from the vehicle. And later on, Lordship, he again committed offences Assam and he was arrested under the charge of Dakati and Arms Act. And later through the production warrant, he was arrested from the Nagaon, Assam in the instant case.
In the submission of the petitioner, one more edit. It is further submitted that nothing was recovered from the possession of the present accused. Present accused, stop. The accused was As per the record, the accused was asked by his employer to accompany the co-accused Rajat Ali to Itanagar, and he had to accompany as Rajat Ali did not how to drive the vehicle. And he had to accompany Rajat Ali only to drive vehicle as accused Rajat Ali did not drive how to did not know how to drive the vehicle. So, okay. So then waiting. No. So rest I'll be there after 2. Yes.
As per office note, ID card in respect of respondent to not return yet.
The informant.
Yes.
Yes. So what do you want? First step or just wait?
In that case, it's on a particular date.
No, then awaited. We do not know when it will come back.
Yes.
So this is A, B or B?
No.
B, A.
Yeah.
Okay.
Yes.
Heard Mr. Jeetado, non-counsel for the petitioner. I have also heard Mr. Jeetado, non-additional PP. You want to take first step or just wait?
Okay. No.
Who is where is the address of the respondent?
It's of Narlagan only, my lord.
So
She's staying,
when did you take a step?
On 19, I think.
19-3.
19-3.
Okay, so then I think it's better to wait for some
Yes.
time. The notice upon the respondent number 2 is still await in view of the above. This is matter after 2 weeks. Okay.
In the meantime, I may be able to file some more documents.
Documents.
Yes.
You're at liberty, you can file more documents into this.
Yes.
File in the form of IA.
Oh.
Okay. Additional affidavit.
Oh.
Okay.
Obliged.
Yes.
The application also.
Yes.
Lordship, as per the direction given by this honorable court in the last occasion, Lordship, that is on 12/3/2024, Lordship. As per the direction given by this honorable court, I was being protected as a interim protection was given to me, Lordship.
Okay.
And I have
This is AB.
yes, Lordship.
Okay.
I have appeared before the IO, Lordship. My statement has been recorded, Lordship.
Statement recorded.
Lordship.
Okay. You have been arrested or not? No.
Formally arrested after that, Lord, since there was an interim protection, Lordship. So I have been released after the recording of my statement, Lordship.
Okay. So what more is required to be done now?
Your Lordship, I've received the case diary. However, Your Lordship, MLC is not there. Only photographs are there regarding their injury.
Now, since he has already been arrested.
Arrest and release.
And release.
Yes.
So what more is to be done?
If he's, you know that he's cooperating.
What is the,
If he is cooperating with the investigation, it's his statement is
Is there
already.
any adverse remark? Adverse report?
Adverse remark, Your Lordship, the weapon used in the commission of the offense was not recovered.
So what is the
However, your lordship, in his statement, he has disclosed it that the same weapon was thrown in the river, and the car which he was using has been sold out, your lordship. He has clearly disclosed everything in the 161 statement. If your lordship required, then your lordship may peruse it, your lordship.
What did the police do then thereafter after disclosure?
Not recovered, your lordship.
They went there.
Your lordship, that part is not there. Your lordship, may I read out the this
Yes.
status report given by the police? The person has been absconding police service ever since the commission of the offense. That part gone. Only after the grant of the interim relief from arrest, he made himself available before me. Third is, the weapon of offense is yet to be recovered, for which the police custody of the alleged accused person is necessary. This is also not required. There is a high likelihood to alleged accused intimidating a key witness of the case, as well as tampering with the evidence if enlarged on bail at the current juncture. That can be, your lordship, also restricted by imposing strict term and condition. A prima facie case is well established against. Yes, prima facie case is there, no doubt. The further judicial remand of the accused is important for undertaking TIP procedure. Only that part.
Okay.
Because, your lordship,
He was not, he was a stranger at the time of commission
yes,
of
your
offense.
lordship, yes, your lordship.
Then you see, could have made a request before the court.
Initially, when the bail was heard, on the day itself, the interim was granted, your lordship. We were not aware of it.
It's very difficult under the circumstances because it appears that for two reasons, he is required to be under the police custody. Since he has already made a disclosure statement, he need to lead for recovery.
Yes, exactly, your lordship.
And also this TIP.
Yes, your lordship.
Very difficult.
Yes, now the thing here is, your lordship, the CCTV footage has already been recovered, and wherein he has been identified. So perhaps, your lordship, even TIP is not required, because TIP purpose is for investigation.
Okay.
And investigation is in right direction.
I was to reflect in that.
Yes, your lordship. Investigation is in right direction, your lordship, because that person himself has stated in his 161 statement, yes, on the day of incident, he was there, and yes, he has admitted that he has committed the offense.
Now this only the recovery part then.
That is the only recovery part.
That has to be done while the accused is still under the police custody.
Yes. And your lordship, what my humble understanding so far as the custody is concerned, your lordship. Custody, the word used custody in the section 27 of the Evidence Act doesn't speak about arrest. Because in every arrest there is custody.
No, that is why I'm saying.
Yes, your lordship.
The IO pro PP
Yes.
may also make an application for custody for a day. On that day, while in the custody, and then the recovery can be made.
Yes. Still, your lordship, even now also, your lordship, if the accused appear before the IO, he will become in the custody. It doesn't mean the arrest has to be done. And he can lead. Yes. For that can be done at the stage also by directing the accused to appear before the IO.
Right.
And cooperate with the investigation so far as the recovery of the weapon is concerned.
Right. While granting the anticipatory bail also, and on the appearance of the IO, the necessary procedure actually has to be completed.
Yes, your lordship.
Let it take 1 hour, let it take 1 hour, let it take even 12 hours.
12 hours
But
also,
it
yes.
has to be completed.
Yes,
So
sir.
during this period, the recovery, leading, etc. can be done.
Yes, your lordship.
But in IO, once they see the orders that you see, and straight away it was fault of court. No, it's
Yes.
not like that.
Yes,
They
yes,
have
your
to-
lordship.
they can follow
Absolutely.
the procedure.
Absolutely, your lordship. And even at this stage also, your lordship, otherwise your report, the purpose of trial also, your lordship, the recovery of weapon is not a condition precedent. If from the other circumstances, if matter, that on the later part.
If you say that he has made a disclosure statement.
Yes, your.
So disclosure statement can also be recorded on the basis of the disclosure statement. Let him lead.
Yes, yes, yes.
And recover.
Yes.
That would be the evidence.
Yes.
So that police probably has.
Yes, your lordship.
Is not doing.
Yes, yes, yes.
So now since he has already been arrested and released, nothing remains.
Nothing remains. Nothing remains.
Then only he can be directed to obtain regular bail from the regular bail.
Your lordship,
While protecting, till then he will be protected only.
Not a lot.
Your lordship, what my humble understanding is, so far as Susila Agarwal case is concerned, your lordship, the validity of anticipatory bail, so far as validity of anticipatory bail is concerned, it's limited in case of some circumstances where regarding, for example, your lordship, transit bail. In such cases, court, usually what court, High Court do, your lordship, court protected the accused until unless he appeared before the regular court, from where the warrant has been issued.
Mhm.
But your lordship, in the present case,
Hmm.
if anticipatory bail, that privilege of interim protection has already been granted, and
Hmm.
court find that his custody interrogation is not required,
Hmm.
then in my humble understanding, your lordship, either it may be made absolute or it may be rejected. Only two things comes up, your lordship.
Now, what I'm saying, it can be made absolute, but then what I'm saying, if this is the condition, then this bail, this can be, anticipatory bail can be of course granted, but then he can also be directed to obtain a regular bail from the trial court.
Your lordship, in my humble understanding, if all the materials are before your lordship,
Hmm.
so far as on today,
Hmm.
if court find that there
Okay.
is
Hmm.
there is no any custody interrogation is required,
Okay.
considering that the earlier interim protection can be made absolute
That
with a
can-
direction to
that
the
can-
yeah
that can-
with a direction to the accused to cooperate with the investigation
Yes, yes. that-
till the statutory period is over, your lordship.
And in the meantime, the court
Yes.
can make an application, as I said. Okay. Mr.
P. Garam, lordship.
Garam, learned counsel for the petitioner. Also heard Mr. Piete, learned counsel, learned additional PP for the state of Arunachal Pradesh. Stop. By an order dated 12/3/2024, this court granted an interim anticipatory bail to the accused on the condition that he execute a bail bond, on the condition that he furnish a bail bond of ₹25,000 with one surety of like amount to the satisfaction of the arresting authority. And to appear before the eye of the case within 10 days. Stop. Pursuant to the said order, where is the document showing that you have appeared and you have been released?
It must be in the CD.
In case diary, your
Where
lordship.
is CD?
Yes, that-
Case diary is here, your lordship.
Pursuant to the said order, the accused, on which date?
Your lordship, I will allow me to find out, your lordship, the date.
Appear before the IO of the case on dash dash, no, stop, no. One is appearance, comma, the accused was arrested. And after completion of the procedure, comma.
On your lordship, 13/3/2024.
13/3/2024. One is appearance, the accused was arrested. However, on the strength of the interim anticipatory bail, however, he was released,
Your lordship, as per the case diary, your lordship, he was not shown arrested.
not shown arrested.
Yes, your lordship. It's
On
written,
what
your lordship, the
basis
accused
was
was not
terminated?
arrested as a matter is sub judice for anticipatory bail hearing.
Not executed.
Not executed. Your lordship, if your lordship allow, your lordship, the bail with a condition in the event of arrest, then bail has to be executed.
Says that you appear and you were
Yes,
arrested,
lordship. I appear before the IO, lordship. My statement has been recorded, lordship.
But it's
not
not,
arrested.
not shown arrested, your lordship. The accused was not arrested as matter is sub judice for anticipatory bail hearing.
Then,
Not shown arrested, your lordship. It is upon the investigation authority whether to shown arrest or not. If the accused is shown arrested, then he has to execute the bail. If not shown arrested, then your lordship not required to execute the bail.
Lordship, it's discretion on the part of.
Part of the
yes,
investigation.
that is there, but I'm not arrested,
Not
not
also-
required.
Not required, because so far as the lordship, the submission made by my learned friend, lordship. The investigation officer, they were under impression that since the accused person is arresting with the investigation part, lordship, with the investigation officer, lordship.
So he has not executed any bail bond.
In case of arrested, lordship, that part is supposed to be given by the IO, lordship. Because the
Your
order,
lordship,
order itself.
Normally, what is the practice, your lordship?
in the many cases, Your Lordship, as and when they appear, when IO shows shown arrest, then Your Lordship, the anticipatory bail order, it come into play.
Yes.
In the event of arrest, then bail has to be executed. But in the present case, he has not been shown arrested for the reason because, Your Lordship, the anticipatory bail was pending. Whether he is required for the custody interrogation or not, that has not been, Your Lordship, reflected by the IO. So far as this status report, this CT is concerned, Your Lordship may kindly peruse this.
Now the
He has not been shown arrested, Your Lordship.
Now the Lordship,
Unless he is arrested, how do we make the anticipatory interim into absolute? Unless he executes the bail bond.
Your Lordship, in many occasions, Your Lordship, the accused normally appear, and the investigation authority,
It is not a case of some other like the where he is not required to be for the custody, interrogation, etc., etc. But then here is the case, the criminal case. Not normally the arrest is required.
Yes, Your Lordship, because in many cases, Your Lordship, when the interim protection has been granted, Your Lordship, the investigation authority, they usually do not shown them arrest, Your Lordship. Where
It becomes difficult even in a trial court also. It becomes difficult unless he is arrested, because later on the complications comes that he is not appearing, etc., etc.
And otherwise also, Your Lordship,
Unless he executes, what is to be then forfeited?
Otherwise, Your Lordship, the pre-arrest bail, so far as pre-arrest bail is concerned, it's a before the arrest, Your Lordship.
Before the arrest.
Yes, yes,
But,
Your Lordship.
but before the arrest only. But then it can be disposed of. It is easier to dispose of if he is shown arrested after obtaining pre-arrest bail, because then even if we make it absolute also, it's very difficult for a trial court. If he abscond, if he doesn't come, nothing to be forfeit.
But Your Lordship, the condition initially, the condition which were imposed against the accused, that condition usually will be continued, Your Lordship, continued by the court, that to cooperate with the investigation.
Under the circumstances, he has to, I think, obtain a regular bail from.
No, Lordship. The whole purpose of anticipatory bail, Lordship, is that, Lordship, since I was in apprehension that I might be arrested in that so-and-so case, Lordship. I approached this honorable court, Lordship. This honorable court, after hearing my submission, Lordship, has granted me an interim protection, Lordship. On the basis of that, on the basis of that interim protection, Lordship, I went straight to the police station on the very next day, Lordship.
Yeah,
I went to the,
you are right. You did right thing, of course.
Lordship.
Appearing before, it was a duty on the part of the police,
Lordship,
to shown arrested and to get
now, Lordship, now, Lordship, so far as the instruction from my client is concerned, Lordship, they have informed me that they have executed a bail bond amount has been also deposited before the in the code of CGM, Lordship.
On the basis of that,
Yeah,
passing on.
exactly, Lordship.
Yes, why he did not ask for that copy the execution? of the bail
Usually,
bond?
Lordship, what they in our state.
Can you fix it on Monday? You bring that.
That will be has to be bring by the police, Lordship. Because everything has to be.
You have the copy.
If he has executed, we have not shown him arrest, Your Lordship. This is very clear from the case diary, Your Lordship.
Say,
Yes. Your Lord,
whether are you?
below it's written in the case diary, status report case, it's written, Your Lordship, in bold, Your Lordship. The accused has not been
Now,
arrested
Lordship,
because the
Now,
bail.
Lordship, the whole purpose is whether the custodial interrogation of the accused person is required or not. Since I'm cooperating with the investigation of part.
No, we will not say that he will not be. You say the police cannot now custody interrogation. For that, he has to, of course, file for cancellation if it is made absolute. So that is different. For that, he has to make an application before the appropriate court.
Yes, sir.
But then now the execution part. So unless he has executed, we can't direct that way. So we'll have to direct to obtain a regular bail from the competent court.
For that, he has to surrender before the learned court below.
That is why I'm saying.
That will be press bail application then.
On the basis of this, he has to surrender, and then he get because in any case he will be released only.
Yes.
Why,
At this stage, Your Lordship, Your Lordship,
on the strength of this bail, anticipated bail, he will be
Lordship,
released
in
only.
fact, to my humble understanding, Lordship, that will create a confusion, Lordship, between the trial court and the Lordship, this honorable court, Lordship. Because since I have applied for the anticipatory bail, Lordship, if the anticipatory bail is become absolute, Lordship, on the basis of the interim passed by this honorable court, Lordship, then that bail, validity of that bail will be go up to till the police has filed a charge sheet before the trial court, Lordship. If your Lordship will direct me to apply for a fresh bail application before the Learned
No,
trial court,
No,
Lordship.
no, thereafter, after appearance, again, you will have to ask for the bail to continuation of the bail granted, earlier bail granted to you.
Exactly, Lordship.
Your Lordship, that has already been settled in your Lordship, Susila Agarwal case, your Lordship, where it says when the High Court has granted an anticipatory bail, an absolute anticipatory bail, there is no any requirement for a renew of this order by filing an application. It will go throughout the trial until or unless he violates the condition.
Precisely.
Of course, but in the earlier court, if he was granted bail, then of course in the say, for example, if he is been committed to the session court, then in the session court he has to pray for.
No, your Lordship, that has been settled. No, that has been settled in Susila Agarwal case, your Lordship. It says when it.
Where it says, do you have that?
I have the judgment, your Lordship, but I have to take the your Lordship print out, your Lordship. I have the judgment, Susila Agarwal case.
Just read that portion.
Okay.
Has the IO said that his arrest is not required?
No, IO says the custody is required for a recovery of the weapon, your Lordship.
Okay, then if it is required, then it will drop.
But your Lordship, when normally when bail is granted, the IO, they have the impression that let the anticipatory bail reach its finality, then only they will decide, because otherwise during the pendency of the anticipatory bail, they usually do not interfere or do not go for this arrest and all. Most of the cases, your Lordship.
Lordship, what my humble understanding is that, Lordship, this anticipatory bail may be disposed with the direction that I, being an accused person, Lordship, I should be fully cooperate with the investigation officer, Lordship.
Okay, let us see that.
Lordship.
Okay, now, not the person that appear before the police, in IO of the case. On date, okay. The counsel for the petitioner submits that the accused on his appearance, the accused was shown arrested by the IO of the case. However, the execution of shown arrested and executed release him on the strength of the interim anticipatory bail on execution of the bail bond. However, the said paper showing execution of the bail bond is not on record. Release him on bail after recording on bail on the strength of so and so. It is further submitted that the police has already recorded 161 CRPC statement of the accused. Yes.
Judgment, your Lordship.
Yes.
Susila
Yes.
Agarwal. The judgment was, your Lordship, reported in 2020, volume 5, SCC 1, page number. Your Lordship, the conclusion has been drawn by the Honorable Supreme Court. May I read, your Lordship?
Yes.
This court, in the light of the above discussion in the two judgments and in light of the answer to the reference, hereby clarify that the following need to be kept in mind by courts dealing with application under 438 CRPC, the anticipatory bail. 1. Consistent with the judgment in Sri Gurbakh Singh Sivia and others versus State of Punjab, reported in 1982 SCC 565, when a person complains of apprehension of arrest and approaches for order, the application should be based on concrete fact and not vague or general allegation relatable to one or other specific offense. The application seeking anticipatory bail should contain bare essential fact relating to offense and why the applicant reasonably apprehend arrest as well as his side of the story. These are essential for the court, which should consider his application to evaluate the threat or apprehension, its gravity or the seriousness, and the appropriateness of any condition that may have to be imposed. It is not essential that an application should be moved only after an FIR is filed. It can be moved earlier, so long as the facts are clear and there is reasonable basis for apprehending arrest. That is first part, where it says even in absence of FIR, anticipatory bail is maintainable. Second, it may be advisable for the court, which is approached with an application under section 438, depending on the seriousness of the threat of arrest, to issue notice to the public prosecutor and obtain fact even while granting limited interim anticipatory bail. Nothing in section 438 CRPC compel or oblige court to impose condition limiting relief in term of the time or upon filing of the FIR or recording of statement of any witness by police during investigation or inquiry, etc. While considering an application for grant of anticipatory bail, the court has to consider the nature of the offense, the role of the person, the likelihood of his influencing the course of investigation or tampering with the evidence, including intimidating witness, likelihood of playing justice such as leaving the country, etc. The court would be justified and ought to impose condition spelled out in section 437 subsection 3 CRPC by virtue of section 438(2). The need to impose other restrictive condition would have to be judged on a case-by-case basis and depending upon the material produced by the state or the investigation agency. Such special or other restrictive condition may be imposed if the case or case warrant, but should not be imposed in a routine manner in all cases. Likewise, conditions which limit the grant of anticipatory bail may be granted if they are required in fact of any case or cases. However, such limiting condition may not be invariably imposed. Court ought to be generally guided by considerations such as the nature and gravity of the offense, the role attributed to the applicant, and the fact of the case while considering whether to grant of anticipatory bail or refuse it. Whether a grant or not in a matter of discretion, equally whether and if so, what kind of special conditions are to be imposed or not imposed are depend on fact of the cases and subject to the discretion of the court. Anticipatory bail granted can, depending on the conduct and behavior of the accused, continue after filing of the charge sheet till end of trial. An order of anticipatory bail should not be blanket in the sense that it should not enable the accused to commit further offense and claim relief of indefinite protection from arrest. It should be confined to the offense or incident for which the apprehension of arrest is sought in relation to a specific incident. It cannot operate in respect of future incident that involve commission of an offense. An order of anticipatory bail does not in any manner limit or restrict the right or duty of the police or investigation agency to investigate into the charge against the person who seeks and is granted pre-arrest bail. The observation in CBI regarding limited custody or deemed custody to facilitate the requirement of the investigation authority would be sufficient for the purpose of fulfilling the provision of section 27 in the event of recovery of article or discovery of fact which is relatable to the statement during such event that is deemed custody. In such event, there is no question or necessity for asking the accused to separately surrender and seek regular bail. CBI Supra has observed that if and when the occasion arises, it may be possible for the prosecution to claim the benefit of section 27 of the Evidence Act in regard to the discovery of the fact made in pursuance of information supplied by a person released on bail by invoking the principle stated by the state in state of UP versus Deoman Upadhyay. It is open to the police or the investigation agency to move the court concerned which grant anticipatory bail for a direction under section 439(2) to arrest the accused in the event of violation of any term, such as absconding, non-cooperating during investigation, evasion, intimidation, or inducement to witness with a view to influence outcome of the investigation or trial, etc. The court referred to in para 9 above is the court which grant anticipatory bail is the first instance according to prevailing authority. The correctness of an order granting bail can be considered by appellant or superior court at the behest of the state or investigation agency and set aside on the ground that the court granting it did not consider material fact or crucial circumstances. See so and so judgment. This does not amount to cancellation in terms of section 439(2). The observation in Sitaram Sitlangi Maitre versus so and other similar judgment that no restrictive condition at all can be imposed while granting anticipatory bail are hereby overruled. Likewise, the decision in Salahuddin Abdul Salamit Sheikh versus state of, yes, this is the last part, Your Lordship. which lay down such restrictive condition or term limiting the grant of anticipatory bail to the period of time are hereby overruled. The bail, your lordship, wherein the limited condition has been granted. Likewise, your lordship has, for instance, said only till he appear before the this learned court below after filing of the charge sheet. It is not restricted to that, your lordship. If once it is granted, it will be an absolute, and the validity will be till the, your lordship, end culmination of the trial. And if state find it necessary to cancel it, then state can always file under section 439 subsection 2 for the cancellation of the same when he violated the conditions, your lordship. So it cannot be limited, your lordship, in my humble understanding, your lordship.
Anyway,
Otherwise, your lordship, after this matter, I will supply the copy of this judgment.
okay.
Apart from your lordship, the record which has been brought before your lordship by the PP lordship, the fact of the case is lordship, the present accused person, he is a villager lordship. Villager lordship. Villager, he came down from the village came to Itanagar for a medical purpose lordship. On the request of his friend, he went to the bar. They were drinking lordship, the victim and the other complainant lordship. It was nothing intention on the part of the accused person as well lordship. It was the scuffles took place between the lordship.
It's on a further submit state. Since the accused has cooperated and is ready to cooperate with the IO of the case for further investigation of the case, IO for further investigation of the case, the bail in the interim anticipatory bail granted to the accused on 12/3/2024 may be made absolute. May be regularized and made absolute. So the Learned Counsel, Learned additional PP, Mr. T. submits that although the accused has appeared before the fairly submitted that the accused has appeared before the IO of the case, and his statement also has been recorded under 161 CRPC. However, since the accused has made a disclosure statement about the weapon of offense, his custodial interrogation is necessary. Be that as it may, since the accused has already appeared before the IO of the case, and he is stated to have been already arrested and released on bail on the strength of the interim anticipatory bail granted to him on 12/3/2024. The matter appears to have become infructuous. In view of the above, the interim anticipatory bail granted to the accused on 12/3/2024 is hereby regularized and made absolute with the same condition that he shall execute bail bond of same condition with the same terms and condition, with the further condition that the accused shall cooperate the IO of the case and appear before him as and when called for, that the accused that he shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case so as to dissuade him from disclosing such fact to the court or to any police officer. Next, that the accused shall he is resident of.
It is the
Okay,
resident
accused shall appear before the trial court regularly.
Lots.
Okay. So this bail application, supposing if he has not yet executed, then it has to be read along with the anticipatory bail. I
Yes.
think, no? This bail application shall be read along with the interim anticipatory bail granted to the.
Yes, earlier interim order shall be made absolute. Your Lordship.
Yeah, made absolute,
Yes.
but then he says that it was executed, released, and you say that not.
No, as per the CD, he is not been shown arrested. Your Lordship.
Yes, for CD, because
Yes.
maybe the executed CD may
Yes.
have forgotten. We do not know, but then let us assume that even if not executed also, that he will be executing.
Yes, yeah.
This bail application shall be read along with the order dated 12/3/2024. Passed by this court. Okay. With the above, this bail application stands disposed of. Okay.
Deeply obliged.
It's, Your Lordship, it's the operating portion is in para 91 onward, Your Lordship, in Susila Agarwal, Your Lordship.
Okay.
Regarding validity, Your Lordship.
Okay. Yeah, this, similar here. Page, para?
Para 91 onward, Your Lordship.
Page number.
Page number is 109, Your Lordship.
Okay, conclusion. Okay, also.
Okay.
It's long.
It's a long judgment. Your Obliged, Your Lordship.
Deeply obliged.
Yes.
Lordship, may.
Yes.
Lordship, both the parties here, the appellant and the claimant, has settled the matter outside the court. And we have entered into an agreement for the payment.
Lok Adalat or just outside the court, right?
Yes.
Not in the Lok Adalat?
Not in the law.
Okay.
May I just?
Yes.
I have executed the agreement. Yes, I am been authorized by the company.
This involves with the insurance company?
Yes.
Okay.
Settlement amount is 6,53,000.
Part, Mr.
Tea time.
Land Council for the, you are for the appellant.
Yes, Lord.
Appellant is insurance.
Insurance.
Okay, appellant, New India Assurance Company Limited. So, I've also heard Miss
R. Taku, Your Lordship.
R.
R. Taku.
Land Council for the respondent claimant. Respondent stroke claimant staff. The Land Council for the appellant submits that the matter has mutually been settled between the parties outside the court. At rupees 6,53,000.
Yes, Lordship.
At compensation of rupees. Then at rupees 6,53,300. Stop. By executing a deed of settlement. Stop. The Land Council for the appellant presented a deed of settlement dated 11 March 2024. And what is this other document?
Lordship, that is the authority, Lordship.
And accompanied by the authority. What is this two? Is same or what?
Same, Lordship. Yes.
Huh?
Same, Lordship.
Okay. By the, okay, this is part of this, I think. On the basis of this authorization, only this settlement entered.
Yes, Lordship.
Okay, which is taken on record, staff. On the basis of the above settlements, the Land Council for the appellant prays for disposing of, and the Land Council for the petition prays for disposing the matter on terms of the deed of settlement entered between the parties. The Land Council for the respondent has also considered the submission of the Land Council for the petitioner. They have already paid or not?
Lordship, this amount 6,53,000 is deposited with the registry of this honorable court.
Already deposited?
Yes, Lordship. It is with the registry.
Before that, and submits after settlement and submits that the said amount of rupees 6,53,000 has already been deposited before the registry of this court.
Yes.
On when?
Rupees 25,000 is for the statutory fees that was deposited on 19/1/2018.
Okay, when it was deposited?
It was deposited in 25/9/2019.
Earlier?
Yes, earlier.
The entire amount was deposited?
Yes, entire amount has been.
And have you
We
withdrawn?
haven't, no, your lordship.
Okay, not a single file?
No.
Okay. Okay, has already been deposited earlier?
Yes.
On
25/9/2019.
Okay, stop. Okay, the Land Council for the respondent appellant considered the submission of the Land Council for the petitioner and has no objection if the case is disposed of in terms of the above settlement stuff. In view of the above, this MAC appeal 3803/2019 is disposed of. Disposed of in terms of the above settlement changes. Above settlement dated 11 March 2024. Stop. Since the amount has already been deposited before the registry of this court, the respondent claimant shall be allowed to be withdrawn.
Yes, Lord.
The said amount from the registry. Okay, with the above, this MAC appeal stands disposed of. Okay.
Obliged, Lord.
Okay, this is, and this is taken on record and marked as X. Okay.
Lordship, Lordship, here, does the service upon respondent number 2 and 3 still yet to be taken?
Okay.
Yet to be completed?
Lordship,
Mr.
for
You are for
respondent
respondent.
1, respondent
Okay.
number 1.
Hard, Mr. You are?
T-time, Lordship.
Okay, T-time, Land Council for the appellant. So this is, we are in IA. Okay, applicant.
Yes.
Also hard, Mr.
VT Guru.
Land Council for the respondent number
1.
1.
Your Lordship, 1 week's time may be given to file a reply for their condemnation.
Who prays?
For the condemnation, they file a condemnation application.
You want to file?
Reply.
Reply, okay. Who prays for allowing him 1 week time to file affidavit? Objection?
Reply, Your Honor.
Okay, reply.
Yes, Your Honor. Oh, yes, Your Lordship.
You are for?
Respondent 1.
Okay, affidavit. Stop. Stop. The office note dated 2/2/2024 also reflected that. Just a minute, huh? Okay, otherwise, notice, I think, complete.
Yes. Service
Just
of
a minute, huh? Then do that, huh? His appearance and Mr. Hmm? Right, his name, huh? Appearing on behalf of respondent number 1, prays for further 1 week time to file affidavit, huh? The prayer is allowed. List this matter after
1 week.
1 week. Okay.
Obligation.
Yes, please.
While the actions of pleading has completed, so the matter is ready for hearing. So this may be posted for supplementary hearing.
Okay, add Mr. Modi, Land Council for the petitioner.
I'm
Also
already
add
responded.
Mr.
Tea time.
Tea time. For respondent number?
Already responded.
Okay.
1 and 2.
For the respondent staff, huh? The Land Council for the party submits that the pleadings are completed and the matter is ready for hearing. So, in view of the above, list this matter for hearing after
2 weeks.
2 weeks.
In supplementary calling.
For admission hearing also, it can be.
For admission hearing?
Yes.
Yes, this is in order.
No.
Okay. Admission hearing, okay.
Obliged.
Yes.
I am for the petitioner.
Your fault.
As per the office record, the service report to the respondent number 1 to 4 and 6 to 10 is still awaiting.
Okay, what do you want? Want to take first step or wait?
Might not wait.
Okay, hard, Mr.
My lord, I'm appearing on behalf of respondent number 5.
Okay. Hard, Mr.
Omodi.
Oh.
Omodi.
Sorry, you are Modi, sorry. Mr. Omodi, Land Council for the petitioner. Also hard, Mr.
Odugon, appearing for respondent number 5.
Odugon. Appearing on behalf of respondent number
5.
5, staff. The office note dated 2/4/2024. It reflects that the service of notice upon the respondent number 1 to 4 and 6 to 10 are still awaited in view of the above. Please the matter after?
Maybe after 6 weeks.
After 6 weeks?
Yes, because there is so many respondents.
Okay. When did you take steps, by the way? Okay, recently?
No, my lord.
They are staying in a faraway place?
Yes.
Okay. Okay, then I think it will time, report time, yes.
Obliged.
Hey, my lord.
Yes.
My lord, I am seeking cancellation of bail granted by.
Cancellation of?
Bail granted by Learned Executive Magistrate SEPA in SEPA PS case number 118 of 2023.
Okay. So how this executive magistrate has?
My lord, it was during the leave
Absence of the JMFC?
Yes.
Being authorized?
Yes.
Okay.
Now, my lord, initially the case was registered under sections 326, 120B, 506 and 34.
Okay.
Subsequently, 307 was added. That is after granting of bail.
After granting of bail, 307?
307 was.
Earlier it was not a 307?
No, 307. 326, 120B, 506 and 34 IPC.
Okay.
Now, of all the offences initially registered, maximum punishment is provided under 326. That is life imprisonment. Needless to mention, under 437, the magistrates are empowered to grant post-arrest bail.
Yes.
However, in case of offences which are punishable with death and life, there is statutory limitation.
Right.
And then kindly take 437 forever.
Yes, that is there.
Yes. Now,
but still then, let us see.
Yes. Four thirty-seven.
Yes.
When bail may be taken in case of non-bailable offence. When any person accused of or suspected of the commission of any non-bailable offence is arrested or detained without warrant by an officer in charge of a police station or appears or is brought before a court other than the High Court or Court of Session, he may be released on bail. But such person shall not be released if there appears reasonable ground for believing that he has been guilty of an offence punishable with death or imprisonment for life. I'm on this.
So this section earlier, section R,
326,
326 is
maximum punishment is life.
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 Okay. And then what else?
Number what diverges from reading of 437 is there's restriction under subclause 1 of subsection 1.
Yes.
That unless the magistrate records his satisfaction that the accused has not committed any offence punishable with life or death, then only he can exercise jurisdiction in matters of these offences. My lord, may come to the impugned order.
Bail can also be granted to the child.
Yes.
Child, women.
44, page 44, madam.
Page 44.
Annexure 9.
Yes.
May I read?
Yes, please.
The bail application number such and such is filed by the applicant, Srimati such and such under section 437 with a prayer to enlarge the accused, Shri Kojam Dada, on bail, who is arrested in this case. Learned counsel, Mr. Such and such, appeared for the bail applicant. Learned public prosecutor, Mr. Such and such, is also present. Today, this case was fixed for hearing. Learned counsel for the applicant, Mr. Such and such, has submitted that the accused, Shri Kojam Dada, is law-abiding citizen. Therefore, he surrendered before the police, and accordingly, the police arrested him on 21/12/2023, and he has no intention to flee from justice. He further submitted that the accused has no any criminal antecedents and innocent in this case. In case of state of Rajasthan, Jaipur versus Balchand alias Bali, held in 1977, I don't know, SRs, it is held that basic rule is jail, not jail, except where there are circumstances suggesting fleeing from justice or thwarting the course of justice or creating other trouble in the shape of repeating offense of intimidating witnesses and like by petitioner who seeks enlargement of bail from the court. Learned defense counsel has also, he further submitted that the accused person is ready to abide by any bail terms and conditions. Accordingly, he prayed this court to enlarge the accused person on bail. Next patient. Sub-Inspector Sergeant investigating officer is present and submitted that he has objected in enlarging the accused till completion of the investigation. Learned public prosecutor, Mr. Sergeant, has fairly submitted to pass any order as deemed fit and proper. Heard the learned counsel for the applicant, learned public prosecutor IO also perused the case records. Upon hearing of the IO, it is found that accused is not habitual offender and he is already interrogated by the investigating officer. This court is inclined to enlarge accused person on bail. Well, the bail has been granted on two premises. These premises are alien to section 437, the restriction part. Unless that restriction is overcome, he cannot exercise jurisdiction. In support of my submission, I would like to rely on judgment passed, full court judgment of this honorable court. Paragraph 20.
Para
20 minutes. In view of the provisions of section 437 CRPC, there appears to be no bar for a magistrate to consider bail application in respect of a person who is accused of an offence exclusively triable by a court of sessions subject to restriction imposed by the section itself. At this stage, we are tempted to recapitulate the following observations of the apex court in the case of Prahlad Singh Bhatti Supraman. Even though there is no legal bar for a magistrate to consider an application for grant of bail to a person who is arrested for an offence exclusively triable by a court of session, yet it would be proper and appropriate that in such a case, the magistrate directs the accused person to approach the court of session for the purpose of getting the relief of bail. Even in a case where any magistrate opts to make an adventure of exercising the powers under section 437 of the court in respect of a person who is suspected of the commission of such an offence, arrested and detained in that connection, such magistrate has to specifically negate the existence of reasonable ground for believing that such an accused is guilty of an offence punishable with the sentence of death or imprisonment for life. In a case where the magistrate has no occasion and in fact does not find that there were no reasonable grounds to believe that the accused had not committed the offence punishable with death or imprisonment for life, he shall be deemed to be having no jurisdiction to enlarge the accused on bail. I will read the last part. The sentence starting with we. We would reiterate that in cases where the offence is punishable with death or imprisonment for life, which is triable exclusively by a court of session, the magistrate may, in his wisdom, refrain to exercise power of granting bail and refer the accused to approach the higher court, unless he is fully satisfied that there is no reasonable ground for believing that the accused has been guilty of an offence punishable with death or imprisonment for life. The impugned order.
So the bail was granted. At that time, 302 was not yet.
307 was not there. Still, my lord,
sorry,
326 maximum punishment is life.
So 326 probably is tribal by
magistrate.
Magistrate.
Magistrate only.
But maximum punishment is life. Madam, not only have 326 for
Up to 10 years, or it may extend it life.
Life.
Up to 10 years.
So under the circumstances, in the case, that the magistrate has no power.
Actually, on the same day, this addition of charge.
On the same day?
Same day.
At the time of granting bail?
Yes.
And it
before CGM registry and granting of bail was took place on before executive magistrate.
Okay.
Bail was granted on executive magistrate on 26th December, and application was prepared before CGM office of the registry.
On that day, whether the CGM came back?
Not available.
Not available. But then it was filed before the office.
Yes.
Okay, yes, please continue.
One aspect, well, 437, yes, magistrate can exercise, but the concerned magistrate has to overcome the embargo. That is, he has to.
So there is no reason.
No reason, madam. No reason that the accused person is guilty of offence punishable with life or death. That reasoning has to be there, madam. The impugned bail order is very cryptic, madam. Bail has been granted on two premises. That two premises is not covered by the restriction part. And another, second leg of submission, one disturbing factor is that the entire exercise was completed in a single day. The bail application was taken up on 26th. PP was appointed on 26th. Case diary was called on 26th. My lord, may kindly have page 42 for a moment.
Okay.
Page 42. There are two orders, madam. Page 42, madam. May I read, madam?
Yes.
Bail application number 84.
This is the same order?
No, madam. Different order. This was
different order on the same day?
Same day, madam.
Let us, where is the earlier order? Where just now we have read?
44 is the bail order, madam.
44 is the bail order on the same day?
Same day, madam.
Oh.
Everything, entire exercise was completed in same day.
So, which was earlier?
Earlier, madam, page 42.
Page 42 was passed in the morning session.
Morning session.
The fixing, next date is fixed on?
Afternoon, madam.
No, accused is informed that he may file bail application. Next date is fixed on. Okay, let us read now, please.
Page 42, madam. The bail application number 84/2023 is filed by the applicant Srimati Melum Singhi Dada under section 437 CRPC with a prayer to enlarge the accused Sri Pojam Dada on bail, who is arrested in this case. Learned counsel such and such appear for the bail applicant. Learned public prosecutor is also present. A copy of bail petition is served to the learned public prosecutor. Public prosecutor shall take steps to produce the CD or bail comment. The IO of the case is directed to produce the CD and bail comment, if any. Next date is fixed on 26/12/2023 for hearing at 2:30 p.m. Now on the same day, page 40 for the impugned bail order.
Where do we find that on the same day, the supplementary charge sheet was filed? Where do we get that?
No charge sheet. The second.
No, sorry.
307 was added.
Intimations
Intimation, my lord.
for addition of,
Addition.
yes, new charge under 307 IPC.
Page 46.
Yeah. This is CD, Your Lordship. As per last order dated 21/2/2024, this court has directed the PP to place on record the CD as passed by the learned trial court prior to passing of the bail in favor of respondent number 2. Passing of the bail order in favor of respondent number 2. CD prior to the passing of the bail order. That is on 26, prior to 26. Whatever CD entry is there. Yes. On 25th, bail comment was made by the IO. On 25th, not on 26th, not on same day.
Okay. So
Learned counsel for petitioner submits that on the same day, I was asked to produce CD and made bail comments.
on 25th, why it was prepared? Comment.
That is not in the record. Why?
Because
But
on
it
20 when the bail application was filed as per record.
22.
Oh, it was filed on
On 22.
And on 22, no any order was passed. On 22, it was passed. It was filed before the Lana CGM court. CGM.
Yes.
And then
It was on that day.
on that the CGM was present. No.
On that the CGM was present.
Okay. Any order passed? CD called for on that day?
No, my lord.
That is not in the
It was
record.
filed before the Court of Chief Judicial Magistrate. In the meantime, he left for leave.
On the same day.
Same day. Therefore, maybe this was transferred to the Executive Magistrate. Because there's a government order which provides that in absence of regular magistrates, the
But
Executive
then
Magistrate,
thereafter till 26, no order was passed.
no order was.
No order was passed.
No order.
Filed, but no order was passed.
There was
Only on
please remand order.
Remand order.
Yes, remand order.
So on the same day, it was produced before the magistrate, executive magistrate on 26.
Yes.
Yes. As per record,
On production, this bail application was moved.
yes, on production time,
Because unless at the time of filing, it was listed before the court, unless they prepare court list, it has to be informed verbally only.
26, my lord, they were produced from police remand. And
Before the magistrate, and on the same day it
Same
was
day.
filed.
no, same day it was hard and disposed of,
Oh, sorry, same day it was heard,
and disposed.
called for the record and disposed of, everything.
Yes.
So what is your submission?
Submission is that since on same day, there was an addition of section 307. And it was not in the knowledge of executive magistrate. But by that time, 326 was there as per record. And 326 is, though it is punishable up to life, but it is triable by magistrate. So the court who has jurisdiction to try has also got the power to entertain the bail. That's my submission.
Now, the submission of the land counsel for the petitioner is that then it has to be considered and the region has to be given that he is satisfied that it is not under.
Yes, satisfaction he has given that, yes, he has rightly submitted. One, that he has no any antecedent. And secondly, he has surrendered himself before the police. This respondent too has surrendered himself.
This comment was prepared on 25.
Yes, as per entry.
It shows on 25, but then why on comment? Why this comment has to make the IO to prepare the comment on 25?
That we can ascertain from the LCR. This is only CD. As I have put paper flag, there's a bail comment raising objection by the IO. And today, counsel for private respondent is also not here, absent.
Counsel for?
Private respondent.
Okay, but for, yes, private response, but for this region, otherwise, that the learned magistrate has not given any reason of his satisfaction. Yes. To, under 26, sorry, 326. Otherwise, otherwise cancellation of the bail would lie only on violation of the bail condition.
Yes, madam. I'm on legal aspect. Madam. Once the offense is punishable with either with death or life imprisonment, there's an embargo, subclause 1 of section 1.
But then here we need to understand, it was not the judicial magistrate, it was the executive magistrate at the time of passing, because he was being endorsed, yes, being empowered under, of course, the notification of the government in the state of Arunachal Pradesh, not applicable, of course, in other states. So we need to understand that he is a magistrate, executive magistrate.
Discharging the function of a judicial magistrate.
Yes, discharging the power, of course, the judicial magistrate. For he exercised the power, and probably then it is triable by the magistrate.
Yes, madam.
That is also possible.
Yes. I'm not saying it is not triable, madam. Once the offense, basically section 437 is offense relating to the punishment.
Right.
Once the offense is
of course
punishable with death and life, then they can exercise jurisdiction. There's no bar as such, but there is statutory limitation. To exercise that jurisdiction, they have to record, the magistrate has to record the satisfaction that that part.
And then whether the learned PP has brought this thing or this law provision into the knowledge of the notice of the, or the knowledge of the learned prosecution. Has he submitted, has he made an objection?
No. As per record,
There's no any objection.
as per record, learned PP before trial court, he simply submits to pass any appropriate order.
Now, under the circumstances, rightly or wrongly, the bail has been granted. Yes. So now, under the this provision, or only for that reason, can it be?
Yes, my lord, because I filed this application under 439(2). 439(2), my lord, may kindly have. CRPC.
Because the addition of 302 was also not into the knowledge of the executive magistrate.
Yes.
On that day.
No issue, but initially it was registered under 326.
Yes.
326, my lord, is punishable with maximum punishment is imprisonment for life.
So, by the way, when it was, now what is the status of the investigation? Charge sheet already filed?
No, still statement of the victim has to be recorded because it's,
I have not yet recorded.
no, actually victim is seriously
Seriously injured.
yes, seriously injured, and
Now also.
as per this CD now also not recorded. It's still at Guwahati. Status report, first page, front page.
See the record, the injury, limbs, hands, or
almost, my lord, the wrist was almost severed. As annexed the photograph.
Okay.
As per photograph enclosed, it's very severe nature of injury. As per photograph enclosed in petition, it's very severe nature of injury.
Page number 20.
Cut over head,
23.
hand almost cut, chop off, almost chop off. It's there photographed in the petitions.
Page number 21. 122 and 22.
It seems the injured person is old man.
Old man.
All men, more than 60 years.
Severe. Head also there is injury.
Yes.
From the very beginning, it should have been 307.
Yes,
Taken to JNRC Guwahati.
Should have been
Report.
307 only, because only, had it been only hand, on hand, then 326, but then it's on head also.
vital.
It's the vital part, it's 307 only.
Addition only done on 26th, when bail was granted.
My query is, because rightly or wrongly, the order was passed. And that, of course, was region, only because the region is not as satisfactorily given in the, while granting bail. Apart from, of course. But then can we?
Yes, ma'am, Malord, may kindly take 439 for a moment. (439) subsection 2.
Four
439 subsection 2.
Yes.
439, special power of High Court or Court of Session regarding bail. A High Court or Court of Session may direct, subsection 2, a High Court or Court of Session may direct that any person who has been released on bail under this chapter be arrested and commit him to custody.
That is there, but then here you have to satisfy for cancellation of bail. You have to satisfy that he has violated the bail conditions.
Yes, there's already bail
You have to file,
cancellation.
and that cancellation also has to be filed through PP.
Well, the very jurisdiction, the executive magistrate, the magistrate can exercise. I have already read 437 subsection
Yes.
1.
That-
Unless that embargo is overcome, unless that restriction is overcome, then the magistrate will have no jurisdiction to grant bail. Once the bail has been granted illegally, that bail order itself becomes known as denial of soft law. In similar situations, this honorable court has previously also cancelled bail. Today, I do not have the copy of the judgment. Similar situation. More so, my lord, I have placed the judgment of full court of this honorable court, which I have read, which says that the executive magistrate under 437 cannot exercise bail jurisdiction unless that satisfaction is recorded.
So just now, which you have read.
Yes, yes.
One more point, Learned Executive Magistrate referred in his order. Oh, yes, Your Lordship. One more point, in addition to that 2 ground, that he has no antecedent, no surrender himself, that by that time, he also referred that Learned Magistrate that he was already interrogated. And it was there. These 3 conditions.
Maybe, but he is on the order passed by the Learned Magistrate. Not on all those, but an order passed by the magistrate granting bail without giving reason on the satisfaction of under 226. He has to cross the embargo.
Yes, that 3 point may be deemed as satisfaction of the magistrate.
So what is your
Treated
submission
as
on merit? Forget it. What is your submission on that law point that he has, the Learned Magistrate has not considered, did not come over the embargo that put under 326. Just now we have.
My lord, the judgment which I have passed over, my lord, may kindly come to paragraph 35. Here also bail was granted, subsequently rejected.
Paragraph 35.
Paragraph 35. Read it, ma'am.
Yes. Ma'am. Yes.
The revision stands allowed and the impugned order passed by the Chief Judicial Magistrate Demaji is set aside. The impugned bail order stands cancelled. It is it is submitted that in the meantime, police has already submitted charge sheet against the accused under section 376 IPC. The accused shall surrender forthwith before the Chief Judicial Magistrate, Demaji, failing which he shall be taken into custody forthwith, and thereafter the matter shall proceed in accordance with provisions of law.
Your Lordship,
Similar facts, my lord.
right procedure to be followed under section 439 subsection 2. I mean, with the opinion of this court that it should be through PP by approaching the investigation.
Even if this also, is it, I think the bail cancellation is to be filed through the PP.
No, my lord, this is an instance of victim. Victim can also file. There's no restriction.
Also.
Yes. This is through son of the victim who is included in the definition of victim.
If suppose your Lordship, IO doesn't need any more the accused to be in custody or interrogated, investigation if suppose completed, then necessity of custody will serve no purpose.
Now, you say that this matter is still under investigation. What is your this status report?
Yes, first please, front please. That was prepared on March.
7th March. This is scanned copy or the original copy they have sent? Okay. How long he was in the custody? 4 days.
Yes, my lord, he was arrested on. He was arrested on.
Yes, 4 days.
20/12/2023 and released on 26/12/2023. Not 4 days, 6 days.
5 days.
Five, sorry, on
26
5
days, 5 days.
Where is the provision? Is there any provision that the private person can also, or the victim can also file for cancellation of the bail? Where do we find that?
That provision.
Because state versus
Yes. I
accused,
understand.
and state represented by PP. It has to be, as for the
But
understanding.
under the CRPC, there's no bar, my lord, as such.
So the understanding is that the state represented by the PP.
PPS.
Even in the trial also, it has to be represented by the PP only. The privately engaged only can assist.
Yes, ma'am.
If you are aggrieved, it has to be through PP as per the understanding. If there is no, you have to satisfy that you have a locus.
Well, there are even now judgments where the cancellation was
Can you
referred by
show
private party.
the judgment where the private
My lord, can you give me 5 minutes?
Yes, please. Or can we take up on Monday?
Yes, so that I can inform the
So,
private respondent also.
Let him also then instruction, and then you also come prepare with on that day.
Yes.
Otherwise, you see, it appears prima facie, it appears that he did not this one give a region, did not come out the embargo imposed
Yes.
imposed on the 26. And that also ruling if the proper along with this, if there is any other to satisfy with that, and along with the locus also. So you also come prepare on that day, full disposal.
The locus.
Okay.
Public.
Okay, hard, Mr. Your Mr.
Sorry, my lord, in case the judgment which I have produced, that was not by the state, it was so moved by the High Court itself.
That is different again.
Yes.
State. Okay, that's okay. The Mr. Tungon.
Yes, sir.
R.L. Tungon, Land Council for the applicants. Also heard Mr. Gita Dolana PP staff is prayed for by the Lana Council for the party. List this matter again on Monday. So you want to take back, you want to retain the
CD, yes.
Okay, please give him that. And this also be on record. Item 12, 13.
Yes, marvelous, marvelous.
Yes.
Marvelous time for the petitioner. This IA has been filed by the respondent, whereby paying for modification and vacation of the interim order passed by this honorable court in the same case, which was passed on.
This is for?
This is the admission, in order stage.
Okay.
Now, at the same time, the respondent also filed the affidavit in opposition. Therefore, my lord, in view of the filing of the affidavit in opposition, the matter is ready for final disposal.
This one?
Yes.
This is
Item 13 and 14. IA is for vacation of the interim order. That is, therefore, my submission is that in the meantime, the respondent also filed the affidavit in opposition. Therefore, no part heard, no piecemeal basis hearing is not required. The matter is going to be disposed of by one hearing. So
this matter?
Yes.
IA.
Both IA and the main.
IA and the main.
Yes.
What is this IA for?
This IA is for vacation or the altercation of the interim order passed by this honorable court in this same case.
Okay, what is the interim order?
The interim order, that the operation of the impugn order should not be.
No, what was the order, impugn order?
Impugn order is the order passed by the ADC Nari not to impugn order is to vacate the erected post. That is the impugn.
Erected post raised by the respondent.
Yes, erected post raised by the petitioner. So I am the petitioner, I have erected the post. Therefore, the impugn order was passed by the ADC that post should be, that erected gas should be dismantled within the certain days. Therefore, while challenging that the order passed by the ADC, this
ADC passed on which basis? What basis? When? ADC passed in the capacity of? By what authority?
Yes, executive magistrate.
Executive magistrate, on what basis he has passed? Under what authority? Is it the Kebang case?
Lordship, may I? Yes, continuation, this is in continuation to the Kebang case.
Kebang, okay, yes, what?
Actually, what has happened is there was Keba case in the year 2019.
Okay.
And that Keba case was executed by the ADC Nari. Here, the petitioner filed for execution of the Keba case, and it was executed, done. after execution of the Keva case, because I constructed boundary wall in my premises.
You also constructed?
No,
both
no.
Have constructed?
Lordship, just, that was
Just a minute, you are for?
I am for the sole respondent.
Respondent, yeah.
And applicant in the IA. Because
This IA is filed by you?
yes, IA is filed.
And then what is the main? CRP.
CRP,
CRP is
yes.
filed by you?
Yes.
Okay.
Then-
LCR also there available? LCR was called for?
Whether LCR
Lordship,
was
record is not necessary here because
Not necessary.
this is
LCR was not called.
then execution was done.
When CRPC, the CRP,
Yes.
record not necessary.
Not necessary exactly because the order is annexed here. The order passed by the ADC in the capacity of the judge in the execution petition. Therefore, they have not made party to the ADC Nari. Had he been passed the order in the capacity of executive magistrate, then ADC Nari ought to have been the party here. They have not arrayed him as party. Therefore, this is the continuation of execution petition. Execution petition was ordered passed in execution petition was complied by me. After the compliance of order passed in execution petition, because by
This CRP is against the execution proceeding.
no, against the order passed by ADC Nari.
You said that the ADC passed only for execution.
Lordship,
The order was basically passed by the Kebang.
Lordship, just 2 minutes, I'll clarify that. Keba passed the decision.
Yes,
Keba cannot execute the order.
yes.
For execution, they have filed.
Keba was in your favor.
Yes, Keba was in the
Keba in your favor. You file
for
execution petition before ADC.
before ADC.
Okay, then what happened?
And then that execution petition was, the order passed in execution petition was complied by me in presence of ADC.
Okay.
The order was for demolition of the boundary wall constructed by me.
Okay, that was demolished.
That was demolished, everything was done.
Okay.
After the demolition, he has again erected gate over the place where the wall was constructed earlier. Because that is the
No. What was the decree then? What was the judgment then?
judgment was, no, judgment, everything
No,
was.
because you demolished,
Yes,
probably,
yes.
probably the judgment says that land belongs to him.
Not land, actually,
What
it's
is-
it's a footpath.
Footpath.
Yes, public footpath. In over the public footpath, my boundary wall was there.
Okay.
So ADC directed me to demolish the boundary wall, remove the boundary wall. Accordingly, I have removed the boundary wall. After I have removed the boundary wall, she has constructed one gate, iron gate. On noticing the iron gate, again ADC directed her to remove the iron gate. So against that order, they have come before this honorable court, saying that that's my private land. You cannot direct me to remove the iron gate.
So according to you, that is not his private land, her private land.
No, nowhere. Even I have annexed in my.
Then why you have demolished your boundary wall? If it is not her land.
Because that was I have if my lord will go through the sequence of the cases, then because
he directly jumped in the end. That is why we are coming back.
Yes.
Going back. Okay. Yes. So you can come back.
My lord may pick the
Go in sequence. Yes.
Sequence is in the year 1997. I resided there. After I resided there, I have constructed my own footpath for easy approach to for the shorter route. Subsequently, in the year 2015 or 16, she developed her land, wherein she constructed her boundary and everything. There was nowhere she is disputing the title of the land. Title is mine. So that footpath was no more accessed by the villagers, even me, because the footpath was being blocked by her. Then, having seen the fencing I have constructed in my own lane, she complained before the Kaba, saying that it was the public footpath. However, she has subsequently blocked the road. Then, because I have already constructed, because title was never the dispute. It was in my own lane. Even her father himself had given me the certificate in the year 1997 itself, saying that this is my lane. So, however, Kaba decided that you cannot block the footpath, though it is not access. However, let the footpath open so that.
Till then, she did not construct. At that time.
No. Her lane is nowhere connected here.
Okay.
So, because I have already constructed my boundary wall, then Kaba decided that no, at least the footpath should be kept open. You cannot construct this.
Who lodged complaint before the Kaba?
Then they lodged complaint before the.
They means
the petitioner here.
because you said that she is not connected with the lane.
No, because this lane goes through his house, though she have another route, but then this footpath is also connected to her
But
lane.
not connected, not directly connected to her.
Not directly
lane.
connected,
Okay.
through my lane.
Okay.
So, Kaba decided that at least you keep open the footpath.
Hmm.
Then, I kept it because it was not access. Then what happened was, because that time before enactment of 2021 civil code, DC was not the authority to execute the Kaba decision. After the enactment of 2021, they have lodged before the ADC Nari, saying that now this Kaba decision should be executed by the ADC Nari.
Till then, you did not demolish.
Till then, I did not demolish.
Okay. Although the Kaba passed against you.
Yes.
Okay. So you demolished.
Yeah, then I demolished because
Okay.
DC also ordered me for demolition of the boundary wall.
Okay.
That is only hardly 3 meters,
Hmm.
not even 3 meters,
Yes.
6 feet,
Hmm.
footpath only. Then I demolished. After I have complied with the order passed in the execution petition by the ADC Nari, then again, on the place where I have demolished the boundary wall, she constructed the iron gate.
For what?
Iron gate, I don't know for what. Because I have opened the road. That's a public footpath. Then ADC Nari, having noticed and even I complained because
you said that her lane is not connected.
yes,
Iron gate for entry to where?
entry to her lane. However, her lane is 100 or 300 meters from there. Because I have
So she wanted to possess all the footpath.
all the footpath.
Okay.
So then
Straight on the footpath, she constructed gate.
yes.
Okay.
Then this order, ADC, it is in my counter affidavit.
That is impugn order.
Yeah, this is impugn order, page number 26.
That is not an impugn order for him.
This is the impugn order in the CRP.
Okay. CRP filed by?
Filed by petitioner.
Okay.
Because she is the petitioner here.
Okay.
And
So,
I have
Let
filed
us
my
see the impugn order just once.
it's in 28, page number 28 in my counter affidavit.
No counter affidavit. It doesn't have, I think, 28, okay? Yes, 25. Okay, just a minute. So in the gate, right side, left side belongs to some other.
Right side, actually, in the gate, right side is forest colony.
Okay,
And then left side is my land.
okay.
Because in between forest colony and my land is footpath.
You constructed a wall through, touching the, making boundary between you and the forest colony.
Yes, exactly.
Okay.
Because it is my land, it is not disputed by them also.
But
And
the footpath is not your land.
footpath was also my land. It is in the record itself. However, I have by my own.
So this is notice only. The impugn order is notice only, I think. notice?
May I read?
Yes, please.
Sorry for interruption,
It's,
my lord.
Just a minute.
It has been brought to the notice of the undersigned that you have erected an unauthorized iron gate obstructing a pathway at Nari village. Whereas the same pathway was opened on 15/07/2023 by dismantling the obstructing structure in accordance to the order passed by the Honorable Court of Additional Deputy Commissioner Nari, Lower Siang District, Nari Execution Case Number 01/2022, Srimati Yaya Bomjen versus Srimati Jumbom Koyu. Such obstruction of way is not only a nuisance but can lead a breach of peace and tranquility. Now, therefore, you are hereby instructed to remove the aforesaid gate and any associated structures within 15 days from the date of this notice. Failure to comply with this directive within the stipulated time frame will result in appropriate legal action against you, and no further notice will be served.
Oh, just one thing, whether this footpath leads only to her lane or to some other lane also. Lane belongs to, or the property belongs to some other person also. This footpath where she has constructed gate. That road, that footpath leads only to her lane or some other.
That lane was used by the villagers.
The villagers. So there is a village beyond.
There was a shortcut to reach the market from that footpath. Once I open, then that footpath will open because she will also have to open. Otherwise, Lordship.
No, so this footpath must be touching her lane, straight to her lane.
Yes.
That is why she has closed.
Yes.
My lord,
Just a minute, let me clear. Okay, just you also, you can also tell me. This,
I am suggesting that.
Submit, please.
In the initial, I am entered into the stage of the case, not on the facts of the case. On the ground that I am not ready to dispose of the matter, since the matter is listed in the order stage.
Okay.
Now the brother has started argument. So therefore.
You said that this can be disposed of. It
If
was
this-
you who started, I think.
If this matter is to be disposed of, then I should be hard fast.
No, that is why, because you started and for disposing.
Let my brother will come with this preparation, because
This
so
is
far his submission
it's
is
in the
concerned
order column.
with mixing
Just a
up
minute.
everything here.
Just a minute. Then let us see. Objection not yet filed. Objection not yet filed. Who filed?
Because no, he has to file the objection because
You have not yet filed.
I am supposed to file the objection in IA, but what I am submitting, my lord, since the affidavit in opposition has already filed in the main case, then there is no purpose to be discussed or decided in that IA part. Now, matter is to be disposed of by hearing.
So this can be fixed for hearing since
Yes.
it is ready.
That's I am trying.
Okay.
That I am saying.
Has it been admitted?
And this should be admitted in the admitting column.
Okay, well, then.
Lordship, the urgency is because she has blocked the
No,
gate.
there is
So
no urgency.
I have, that is the reason why I have filed the IA, because IA is for the alteration and modification of the interim order passed by this honorable court in the motion stage.
Right.
So I have filed IA, and since November 2023, they are seeking to file objection in the IA. Therefore, I'm insisting on IA.
So then you file objection here. Because this might take longer time. Otherwise, you see, next week if you want, you file objection here also. We'll fix this. In the admission stage, we'll try to dispose of. We'll make an endeavor. Okay. You file here also objection.
If so, advise. Otherwise, my lord, I am confident to cover with my.
Because next time, if the same submission is not made, then this situation might not arise.
Yes.
So that is why you file objection also. We'll try to make an endeavor to dispose of the entire matter next week.
In the case, my lord.
What exactly, my lord, I am trying to point out.
Bihu, because
after Bihu,
may not be here.
Okay, that can also be.
After Bihu, probably after election.
After election.
Okay, for one it is after election. For one it is after Bihu.
After Bihu and election is almost the same.
The outlook, the view is different. Okay. Okay, then hard, Mr. This is filed by, objection is filed by you. Okay. Yeah, Mr. Koyu.
Yes.
Okay, Mr. R. Koyu, learned counsel for the appellant. Sorry, applicant. Also heard Mr. Modi. Mr. Modi prays for further one at a time to file objection. The prayer is allowed. List this matter after. Then it will be
After 3 weeks.
okay, after 3 weeks. Okay.
In the meantime, I'll let interim order pass earlier, we continue.
Okay, in the main case.
Main case.
Okay, in the main case, Mr. Modi, learned counsel for the petitioner, and Mr. Koyu, learned counsel for the respondent staff. List is matter after 3 weeks. Stop. In the meantime, the interim order passed earlier shall continue. Yes.
May I use?
Yes.
Your Lordship, earlier I had not made the victim as a party to this instant
Okay.
bail application.
Sir, what case is this? Also, Mr. Ete, learned additional PP, Government of Arunachal Pradesh staff, by filing this, by this application, the applicant prays for impeding the informant, namely,
Ty Robin.
Your Lordship, what would be victim, your Lordship? Victim father means victim here because your Lordship,
father is a victim.
victim include victim father, parents also.
Okay.
So far as implement is concerned, your informant is not
Implement of the
mandatory. Victim is mandatory actually.
Okay, of the victim.
Yes, victim family.
Since victim is minor, father.
Yes, father will be represent, no issue, your
Staff,
Lordship.
victim, staff, In BA number 35 AP 2024. Staff, the prayer for implement has not been objected to by the learned additional PP. Staff, accordingly, the prayer is allowed. Let the victim represented by his father or mother? Mother, I think.
Father.
Mother.
Father, your
Father,
Lordship,
father.
I think this is Srimad, huh?
It's father, your
Your
Lordship.
Lordship, they have not reflected in the course title, but in the paragraph
Father.
3, paragraph 3, your
Paragraph
Lordship.
3.
Yes, your Lordship.
It's father, your Lordship.
Victim represented by his father, Ty Robin.
Yes.
As respondent number 2 in the bail application number 35, 2024. So, the registry shall do the needful for inclusion of the respondent number, newly included respondent number 2 in the course title of the bail application, in the bail application number 35, AP 2024, staff. With the above, this IF stands allowed and disposed of. In the main, in view of the hard, both same, in view of the order passed in the IA Premier number 22 AP 2024, whereby the father of the victim, the victim represented by father has been impleaded as respondent number 2. The petitioner shall take steps upon the respondent number 2 by a registered post with AD.
Yes.
Within 5 days from today.
Yes.
Staff, list this matter after
2 weeks.
3 weeks.
3 weeks, your Lordship.
3 weeks, I
Yeah,
think. 3 weeks. Okay,
All right. Obliged.
Deeply obliged.
IA disposed, item? Okay. No one appears when called, when the matter was called, so in view of the above, list this matter after 3 weeks, okay. 15, you are in the 15?
My lord, item number 11, I have forgot to mention the interim order.
Okay, no problem. Item 11, who has recorded? You have taken. Okay, so interim.
Yes, yes.
Okay, in the meantime, the interim order passed earlier, so continue till the next date. Okay. Done, over.